got together in Delhi, and one of the things that they discussed and one of the recommendations that came out of that conference was that there must be something like a review mechanism to see that nobody is detained unnecessarily in prison. And Rajasthan was the first state, was a pioneer state in establishing such a committee, which was called Avdik Samiksha Samiti. It is still working there. So, we have worked a lot in Rajasthan. We had a demonstration project. HRLN has worked in Rajasthan, and from there, all our learning has been from Rajasthan. What works on the ground, what doesn't work, how the entire process of under trial review committees, and based on that, that is how we've been recommending in the re-inhuman matter in the Supreme Court. So, I'll quickly skip all this. This is already covered. Okay. So, like Sweetie said, that there are now 14 categories which are there. I'll quickly go one by one. And you don't need to note because we have a pamphlet, a one-pager on under trial review committees. So, you will get that. So, the first one, we've already spoken a lot on section 436A. So, as lawyers, what we could do as regards these 14 categories, that is what I'm basically putting up before you. So, to get a person released on personal bond with or without surety, so we all know about the landmark Moti Ram judgment, and and of course, section 436A, it is. We know that even after the half term is completed, there is still a discretion with the magistrate. But we should try to get the person released on personal bond. Unable to furnish bail and are still in custody for that reason. This was, as Sir said, this was the second category. And we know that there is a section 440 of the CRPC, which allows the magistrate to reduce the surety amount. So a bail application must be filed in the court if the surety amount is too high, because it clearly says that the socio-economic background of the person must be kept in mind while deciding the surety amounts. And the courts have always been very clear that poverty can't be a reason to incarcerate anyone. So that has to be taken into account. Section 320, which talks about compoundable offences. So that's the third category. So if you have any of your clients, so please check that whether their case comes under the compoundable category, and if the case can be compounded. There are two categories, as we know, under section 320. Some offences can be compounded with the permission of the court, and some can be compounded otherwise. Section 436, Sir has explained it very well. That if 7 days are complete, then you are considered an indigent, and therefore you should be released on personal bond. First time offenders between the ages of 19 and 21 who are in under trial custody for offences punishable with less than 7 years of imprisonment and have suffered at least 1/4 of the maximum sentence possible. And therefore the court said that in such cases, because they are first time offenders, the Provision of Offenders Act must be implemented. So, as lawyers, we must ensure that Section 3 or 4, in this case Section 3 of course, is taken into account if the person in the course of the trial is convicted. And we must press on to the court to ask for the report of the probation officer. Then imprisoned for offences which carry a maximum punishment of 2 years. So, if we look at the list of all the offences where the maximum punishment is 2 years, there are 11 offences which have basically except for the 11 offences, all the offences are bailable. So, in that case, section 436 must apply, as we just discussed. And of course, again reiterating on the issue of implementation of Probation of Offenders Act. Then your section 167, Sir has already explained it. Yes, detained under chapter 8 of CRPC, which is your section 107, 108, 9 and 151. I've heard that in some states, persons who are arrested under this section are not considered as under trials. I think in West Bengal, that is a situation where they are considered as detainees. So, and that is why the role of the district magistrate comes into play as to why they are part of the under-trial review committees, because they are the executive magistrates who take care of these cases. So, in this case, as lawyers, we must file an application under section 123, which allows the magistrate to either reduce the surety amount or discharge the person altogether. Section 437, this gives certain special considerations for some vulnerable categories, so sick or infirm, or people who require specialized medical treatment. And similarly, we have a special consideration for women prisoners under section 437. So as far as possible, we should use these provisions in our bail applications when we are drafting our bail applications. These are very, very important. Yes, this is again section 437(6) of the CRPC, where case triable by magistrate and trial of a non-bailable offence has not been concluded within a period of 60 days from the first date fixed for taking evidence. So again, I think as lawyers we should keep track of all these dates when the first, when the charge sheet is supposed to be filed, when the 60, 90 or 180 days is supposed to be over, when does this, the date comes over under section 437. So if we are vigilant about the rights of our clients and we file appropriate applications at the appropriate time, then we'll be able to help our clients more effectively. Accused of unsound mind, now this has to be dealt under chapter 25 of the CRPC, and there were amendments in 2005, and where they say that if a family member can take the responsibility of a person who's mentally ill, so then the person can be discharged in the care of the or can be released on bail in the care of the person. So we can also file the application under section 330, and of course they should not be in prison. First of all, they should not, mentally ill people should not be in prison, but if at all we find someone, then this is something that we should take the recourse. Women offenders, I have already mentioned. Convicts who have undergone their sentence or are entitled to release. Now here I would like to mention one important system that is prevalent in prisons, that is a system of history tickets. Are you aware of history tickets? So this is basically, you will find in every state prison route. So in prisons, when you see that the information is kept theme-wise, there will be an admission register, there will be a medical register, there will be an admission register, all those things will be kept theme-wise. But the information as regards an individual, so if I am in prison and what happens to me as soon as I enter the prison, everything gets recorded in history ticket. So if you want to know any information about your client as to whether the medical examination was done on time or not, whether, how many times the person was actually taken to court if he's under trial, taken to court when the due date was there, how many times they were not taken to court, all this information is there in the history ticket. So that's a very important tool for lawyers, that you can get a copy of a history ticket, and based on that you can go to the court and file a claim. And implementation of section section 3 of the Probation Offenders Act that Sir has explained. Now, in 2015, in April, when the Supreme Court ordered for the establishment of these under-trial review committees, in November 2015, we filed RTIs to all the state legal services authorities to basically check how these committees have done in the first 6 months of their establishment. Whether at all these under-trial review committees have been established, whether they are following the mandate, and at that time, as Sunilji said, that there were only 3 categories of cases that the committee was supposed to look into. So when we filed and we got responses from 26 states and UTs, 357 districts responded, 155 actually provided us information, and we analyzed the minutes of the meetings of these under trial activities. 256 minutes of the meetings we analyzed, and what we realized, the huge gap between what's there on paper and what's actually on the ground. So whether under trial review committees are held quarterly, 60% of the districts did not comply. Now, why I would say, because see, if you consider the mandate of these committees is to hold meetings quarterly, right? And if you consider January to March as one quarter and April to June as second quarter, if you have the meeting in first week of January and in the last week of June, it is still quarterly in the technical terms, but there is a gap of more than 5 months. So, so we recommended that this has to be considered as not less than 3 months. The meeting has to convene within 3 months. Number 2 was the full mandate followed. So there were only 3 categories at that time: Section 436A, bail no surety and compoundable, and we saw that 436A was taken up inevitably everywhere. They did look into that nobody should be detained beyond half term, but other 2 categories are stated in some places, like 160 out of 256 and 139 out of 256. So only 54 out of 357 districts actually complied with this. How many under trials were released? Because ultimately, what is the purpose of these under trial review committees? That they have an impact, that the persons are actually released. So we had a lot of recommendations. A lot of recommendations were made by these UTRCs, and ultimately we saw that out of 2,112 recommendations, 515 only were released. But we consider all these as teething problems, and a lot has changed since then. I mean, I'm talking about this November 2015 when these companies have just started. And NALSA, and after the efforts of Mr. Rathi, it has really worked very well now, and we will see that because now we filed another set of RTIs in all the SLSAs, and I'm very hopeful that after the SOP comes into play, because that was one important thing for us, that the entire procedure of the UTRCs is taken, because there was a lot of discrepancy that we found in our first report. So I'm very hopeful that after the SOP, it's very progressive. In fact, they have gone one step ahead, because a lot of time people say that these are the provisions that the court are anyway supposed to look into, right? I mean, you don't need an oversight body to see whether this is law. This has to be implemented. But so now they have gone a step further, and they've said that not just these provisions, but the UTRC must also look into the delay in trial, as to why there is a delay. So I'm very hopeful with the new SOP that the functioning of the UTRC is improved. Thank you so much.
In the year 2017, we had 2,285 UTRC meetings, and only 3,913 people were released. One thing which we found is difficult to maintain the data, because it's once in 3 months we are meeting. The frequency of people coming to jail and leaving jail is so high that by the time the UTRC's recommendation process is completed, the person will be out for other reasons. So that data was not working. So we prepared an SOP because Supreme Court wanted a real-time tracking. What we did at our end, and we are trying to do, is we are having our own IT team. We'll keep a digital tracking of every incident. So another thing which we want to do is start in due course of time, because whatever UTRC is doing today is only filtration. The data which is available with the courts, with the jail, they are just filtering the data, and their recommendation is not for bail, their recommendation is for consideration for bail. Nobody can snatch away the discretion of a court to grant or not to grant a bail. So even in these 3 senior most police and executive people, coupled with the jailer or coupled with the chief public prosecutor, they cannot substitute a magisterial judicial discretion. So this is only a recommendation for consideration. Now this filtration, at the end, NASA found that this can be done by using filters and softwares. We are even contemplating using artificial intelligence once we have the database. And Honorable Supreme Court has appointed NALSA as a nodal agency for all the problems faced by under trial prisoners in this criminal case, and all the problems faced by convicts. In a case titled Shankar Mehta versus State of Bihar, you can follow that case. We have prepared an SOP in that case as well, and that I'm carrying that SOP is available on NASA's website as well. The Shankar Mehta case is also very important, which we are doing. And just a quick insight to all of you. We have, you see, when the digitization picked up in criminal justice system, unfortunately, it was not done as a team. We all understand we have police as a pillar of criminal justice system, we have jails, and we have judiciary. Unfortunately, all three of them started digitization independently or without consulting each other. So when we talk of police, MHA started creating a network called CCTNS. Many of you must have heard of Crime and Criminal Tracking Network. So they started digitizing the police stations, networking the police stations within the state, beyond the state, and everywhere. Now, what the jail people started, Ministry of IT, they started, it was a PMS as we call it, you know, we developed it in Delhi, prison management system. It was adopted by Ministry of IT and they call it e-prisons. So, out of 1300 odd jails, 700 to 800 have adopted it. Haryana has its own software. They are not party to e-prison software because they developed, because they were lucky गुड़गांव में बड़े रिसोर्सफुल लोग आते हैं तो एक आईटी का बंदा आ गया उन्होंने उसी से बनवाई है कहीं पे तो वो बनाते बनाते उसने उनका अपना सॉफ्टवेयर बना दिया and same way I think Gujarat or Goa also has its own software. And meanwhile, what judiciary did, judiciary created a non-CIS systems. Initially, it was a Pune-based model. Now CIS 1.0, 2.0, last month CIS 3.0 have been rolled out. So now we have three identical, three separate independent IT structures. Now what they are trying to do is making air bridges among them. They call it ICGS, Integrated Criminal Justice System. You may have heard of this phrase as well. Now ICGS is today working as a search engine among these three verticals. Now they have a lot of problems, there are a lot of gaps. So we at NASA are trying to bridge those gaps. Inshallah, we'll do that very soon, and then within next 3 to 6 months, we'll give you solutions that we want to do away with UTRC altogether. In this sense, at least from this job, because they are doing filtration, and this filtration can be done by the software. They can be system-generated lists, and these lists can be sent to the court for consideration. So this will be done. We at NASA have suggested separate duties which we according to us should be carried out by the judges, by the UTRC, and one of them is most important is, as I shared with you, that no person is sent to jail without a judicial order. So the remand order, we have given templates in the report. I am not going into the details of the report because it will be time consuming. We have given 8 to 9 suggestions. For a judicial authority who is sending people to jail. We have redesigned the custody model. One of the biggest gaps we can understand is that when a man is sent to or a woman is sent to jail, I think my voice is louder than the disturbance, so please pay attention. It's very important because when a person is sent to jail, he is sent to jail as per the information available in the FIR. And you are aware when the charge sheet is filed, the details of the FIR may not match with the charge sheet. FIR can be under 307, charge sheet can be under 302 if the person died by the time. FIR can be 325, charges can be 307 or 308. So what the jail continues to maintain the data of the originally sent. So now that, and suppose when we talk about 167 bail, 167 when the 60 or 90 days is completed, jail people do not know because they are never told when the charge sheet is filed. So there was no exchange of data between the police and the jail and the judiciary as well. So we are trying to create software APIs so that these data can be exchanged. So we have created a new remand paper which has been adopted by several states ever since we filed in the Honorable Supreme Court, and this custody warrant is there. As far as what UTRC should be doing, we have, I just give you few examples. The criminal justice system has several things which are ailing this system. prison overcrowding, this, that is one part of it. Delay in trials, non-filing of forensic reports in time, failure of police to produce witnesses, the hostility of witnesses, the witness protection issue. So there are a lot of issues which we think that the lack of infrastructure and manpower. So UDRC as a body should be focusing on strengthening the criminal justice system other than simply scanning the raw data into a filtration process which can be done by the technology. So before we take up the question answers, I'll request Sunil.
जो टॉपिक है सेंटेंस रिव्यू बोर्ड का है, इससे पहले जस्ट मैं आपको बताना चाहता हूँ कि एक कमेटी थी, देयर वाज वन कमेटी हेडेड बाय जस्टिस के मुल्ला, जो उन्होंने रिकमेंडेशन दी थी, उनको कहा जाता है कि दीज आर द बाइबल ऑफ रिफॉर्म। जो जस्टिस मुल्ला ने रिकमेंडेशन दी थी, 2012 बाइबल ऑफ रिफॉर्म। उन्होंने कहा था, जस्टिस मुल्ला इन हिज रिपोर्ट हैज सजेस्टेड that 80% of the arrests are unwanted, and I fully agree कि 80% जो arrest है those are unnecessary, only 20% should be in the jail। मैं आपको explain करता हूँ। 1986 Charles Soberer escaped from the jail। Basically, I have worked as for 15 years. I have worked as DSP and SP of the jail. Charles Soberer skipped the jail in year 1986. When he skipped, he drugged the staff. Staff was drugged. Every gates were open, and everyone know that gates are open. Despite that, there were 2,000 prisoners in that jail. Despite that, only 13 prisoners escaped from the prison. Rest all stay inside the jail, fully knowing that कि भागने की बड़ी गोल्डन अपॉर्चुनिटी है, जेल खुली है। तो हमारे प्रिजनर जो है, जब भी हमारे प्रिजनर्स में एक भजन मंडली है, प्रिजनर्स काफी अच्छे भजन बोलते हैं, बहुत अच्छे गाने गाते हैं। तो उनमें ना एक गाना बड़ा मशहूर है, मैं 4 लाइनें आपको सुनाऊंगा, 4 लाइनें खाली सुनाऊंगा। वो ये कहते हैं असली क्रिमिनल तो बाहर है, असली क्रिमिनल तो कहते हैं बाहर है, हम तो वैसी सर्कमस्टांसेस के मारे हुए हैं कि जो जेल में है। जो उनकी 4 लाइनें होती हैं वो ये है, मुजरिम ना कहना मुझे दोस्तों, मुजरिम ना कहना मुझे दोस्तों, मुजरिम तो सारा जमाना है। मतलब एवरीवन इज क्रिमिनल। पकड़ा गया वो चोर है, मतलब हम पकड़े गए हैं, हम तो चोर हो गए, बाकी सब जग श्यामा है। मतलब बाकी सब जग जो है श्यामा है, क्योंकि वो पकड़े नहीं गए। नाउ आई एम कमिंग ऑन दिस सब्जेक्ट। दिस इज सेंटेंस रिव्यू बोर्ड। दिस सेंटेंस रिव्यू बोर्ड वाज constituted on the advisory of NHRC, and this NHRC they sent the advisory to all the state government, and most of the state government they have accepted their recommendation in toto. The role of the sentence review board is to advise the governor or lieutenant governor as to which prisoner, which life convict prisoner is to be prematurely released. Prematurely released. Life sentence means imprisonment till last breath, till natural life. Life imprisonment literally means, ठीक है ना? ये तो सुप्रीम कोर्ट ने भी कई केसों में कहा है। पर अगर आप उसको जल्दी छोड़ रहे हैं, मरने से पहले आप जल्दी छोड़ रहे हैं, तो that is called premature release, which we are granting through sentence review board, and sentence review board is giving recommendation to the lieutenant governor. In brief, I am telling you, the sentence review board state that the prisoner who has undergone 14 years of actual sentence, 14 years of actual sentence. Before 1980, it was 14 years of sentence with remission. Remission amounted to around 5 years. Basically, one life convict was being released after 9 years of actual imprisonment. मतलब डकैत जो होते थे वो तो जेल में डकैत जो होते थे वो तो जेल में होते थे और मर्डर वाले पहले छूट जाते थे. This was the scenario before 1978. Then 1978 में जो है ये अमेंडमेंट लाए 433A. 433A was 433A was created, under which every life imprisonment prisoner has to undergo actual 14 years of sentence before his case can be placed before the sentence review board for recommendation of his case. When the case of a prisoner is placed before sentence review board, the judgment of the case, police report, probation report about his rehabilitation are also enclosed with that the report of the superintendent jail. The sentence review board is headed by the, as per NHRC guidelines, sentence review board is headed by the respective jail minister of the state. He is the chairman. Then Secretary Law, Secretary Home, the CPO, Chief Probation Officer, and Director General Prisons are its members. They are required to hold the meeting once in a 3 months. Once in a 3 months, the meeting of the SRP board is convened. And during the meeting, they consider each case, they consider the case whether this case is fit for the recommendation to the Lieutenant Governor. The board also consider that there are the chances of rehabilitation of prisoner when he is released. If they see everything is okay and police report is also okay, most of the time police invariably in every case, they are opposing the release of the prisoner, whether it is on the parole or whether it is for the premature release. They consider everything and then they recommend the case, looking at his conduct in the prison, they recommend his case to the governor. An important thing in this sentence review board is that the prisoners who have committed the murder and also who are committed along with us in the rape, in the terrorist activity, or in other serious offences, they have to undergo total 25 years in jail. That is the maximum limit. But if someone has committed simple murder simpliciter, he has to undergo maximum 20 years with remission. 20 years in normal case, in normal circumstances, 25 years in extraordinary circumstances where the murder is abnormal. There is no uniformity in the state about the release of a prisoner. Like if you are in Delhi, then it is mandatory that you will undergo 14 years, actual 14 years in the jail. Whereas if you are in the Andhra or if you are in the Kerala, you could be out after 8 years or 9 years by using the governor extraordinary constitutional power under Article 161. तो कई बार लोग कहते हैं कि हमने दिल्ली में मर्डर किया इसीलिए हम 14 साल जेल में हैं. अगर हमने ये मर्डर केरला या आंध्रा में किया होता तो शायद हम 8-9 साल में जो बाहर हो जाते.
वैसे समय कम है तो बोलने के लिए तो बहुत कुछ है, पर मैं बहुत कम शब्दों में ही बोलूंगी. जो मतलब जैसे कि मैं खुद भी एक टीचर थी. टीचर कराने के बाद उनके माँ बाप के नाम पे, माँ बाप के नाम पे अंदर किया और उनको कितना यातनाएं दी. इस तरह से और भी हमारे जो साथी हैं तो उनके साथ भी इसी तरह का होता है छत्तीसगढ़ में. तो मैं एक मतलब अपने बस्तर में ही है बामन कड़ती करके, तो उसकी बातें ज्यादा बताएंगे. कि वो जो किस तरह से उन्होंने फाइट किया और उसको कैसे जेल में ले गए और उसके बाद जेल जाने के बाद उसके साथ क्या किया। और उसके जो एक मतलब भाई था बीमा और उसकी साली सुमति थी, और उसको जब वो बाजार आए थे, बाजार आने के बाद वो मिले उसको वाहन करती को, उसके बाद पुलिस जब वापस जा रहे थे तो उठा लिया उन दोनों को, साली को और उसके भाई को। उठाने के बाद दूसरे दिन उनको एनकाउंटर कर दिया और उसके बाद बामन को बता नहीं गए कि भाई तुम्हारा भाई माओवादी था, तुम्हारी साली माओवादी थी, उनका एनकाउंटर हुआ। तो बामन का कहना यह था कि मेरा भाई मेरे साली माओवादी नहीं है, वो तो कल बाजार आए थे मिले हैं, और ऐसा कैसे हो सकता है। तो हमको उस बात में ये भी पता चला कि उनको तो मतलब लगभग 4 बजे के आसपास पुलिस उठाई, रात को रखी, 2 बजे ले गई जंगल में और लड़की के साथ बलात्कार किया गया। उसके बाद रात को ले जाके सुबह के मॉर्निंग के समय 9-10 बजे के आसपास उसको एनकाउंटर कर दिए और उसके बाद तुरंत दूसरे दिन 3 बजे के आसपास डेड बॉडी को वापस बामन करती को दे दिया गया। तो बामन करती ने ये कोशिश किया है कि इसको मुझे लड़ना है कि ये गलत हुआ है मेरे भाई मेरे साली के साथ। तो उस वक्त भी मैं दिल्ली में थी, वो किसी तरह ये सबसे संपर्क किया और उसके बाद बहुत कोशिश किया, किसी ने उतना मदद ना मिलने पर मुझे से कहे तो मैं यहाँ से दिल्ली से गई, जब तक कि 12 दिन हो चुका था मेरे वहां जाते तक। लेकिन बामन करती को लास्ट में जो HRLN है अभी मतलब कोर्ट में वो सब करते हैं, तो रजवी स्टूडेंट को हमने बताया कि ऐसा ऐसी बात है, तो उन्होंने कहा मैडम उनका केस कर देते। तो उसके लिए हम लोगों ने केस किया, केस करने के लिए आ रहा था बामन करती, रास्ते से पुलिस उठा के उसको पकड़ ली। उसके बाद हम फोन करते रहे और हमारा फोन नहीं लगा और उसको ले जाके एक दिन थाने में रख के इतना मारे, उसके कुछ अंगों को काट दिया गया था, उसकी इतनी टॉर्चर किया और जेल में डाल दिया। जेल में डालने के बाद हमको पता चला कि जेल में डाल दिया गया। तब जेल में मिलने गए बामन से, तो बामन ने खुद बोला देखो मेरे साथ कैसे कैसे हरकत किए हैं मैडम, मुझे रात भर मारे हैं पुलिस ने और मेरे को जेल में डाल दिया। लेकिन मेरी जो बहन मेरी जो साली और भाई है उसके लिए मेरे को लड़ना है। तो ये गांव वाले उस डेड बॉडी को 12 दिन से भी रखे हुए थे और बामन की बात को हमने जेल में मुलाकात करने गए। जेल में मिलने के बाद उनके गांव जाने के 40 किलोमीटर लगा हमको, तो वहां जाके हमने देखा तो वाकई डेड बॉडी 12 दिन से गांव वाले रखे थे। इसलिए रखे थे क्योंकि वो निर्दोष थे, वो किस तरह से मारा गया। ये बामन के कहने से मैं वहां चले गई, देखे तो डेड बॉडी पड़ी थी। फिर हम लोग ने कोर्ट में लगा कि 21 दिन बाद उसके डेड बॉडी को निकाल उसको दोबारा पोस्टमार्टम के लिए भेज दिया गया। जब डेड बॉडी जब देखने भी गए तो उस समय उसकी आंखें गायब, उसकी किडनी गायब, तो ये बात भी काफी मीडिया में हम लोग लाए। तो जो बामन है ये सब तो हुआ, लेकिन बामन किस तरह जेल में उसकी यातनाएं को सहा। बामन एक एनएमडीसी वर्कर था और उसको जेल में डाल के उसको पूरी माओवादी और इतने बड़ी अटको माओवादी बना दिया गया और ये कहा गया बामन ने इतने लोगों को मार डाला है, उन्होंने हत्या किया। लेकिन उसका पूरा फर्जी केस था, उसको बाइज्जत रिहा किए। रिहा करने के बाद फिर वापस बामन गाँव आया, फिर बामन के परिवार से फिर एनकाउंटर कर दिया था। फिर एनकाउंटर कर उसके लिए उस बामन ने फिर भी कमजोर नहीं हुआ, उसने फिर से धरना प्रदर्शन किया, आगे बढ़ा कि मेरे फिर रिश्तेदार को मार दिया गया है, इसके लिए लड़ा। अब बामन के 4 बच्चे हैं और बामन के साथ अब जो एनएमडीसी वर्कर था उसको वहां से निकाल दिया गया। आज बामन मजदूरी करने भी जाता है, उसको काम नहीं दिया जाता, वो अपने बच्चों को कैसे पालेगा क्या। ये मतलब जो भी वहाँ की आवाज उठाता है, आदिवासियों की आवाज उठाता है, वहाँ की जल जंगल की आवाज उठाता है, उनके साथ ये चीज जैसे सर अभी कह रहे थे, तो सिस्टम चेंज होना चाहिए। सिस्टम कहाँ से चेंज करें, जो सत्ते में बैठे हैं वही इस तरह की करने के लिए मजबूर किया जा रहा है, तो सत्ते में बैठे लोग इस तरह के सिस्टम ला के खड़ा करते हैं। हम तो ये भी मानना है कि पुलिस के साथ हम अक्सर बोलते हैं पुलिस ने ये किया, पुलिस ने वो किया, पुलिस ने ऐसा, लेकिन पुलिस को तो सरकार करवाती है। पुलिस उस सरकार के मतलब नीति के अनुसार करते जाती है। हमारी लड़ाई भी तो सरकार की नीति से है कि ऐसे सिस्टम ऐसी चीज क्यों ला, हर वर्ग के लिए संविधान है। तो भाई अगर हम जैसे लोग अगर जेल में जाए तो इतना देना तो नहीं चाहिए। ऐसी इतना कोई पत्रकार से है, हम खुद से, मैं तो खुद एक टीचर थी और मैं खुद एक टीचर रह के मैं ये चाहती थी कि मैं एक आदिवासी हूँ और मैं बेहतरीन मेरे आदिवासी कल्चर और मेरे आदिवासी बच्चे और मेरे आदिवासी के क्षेत्र में अच्छी से अच्छी शिक्षा दूं और अच्छा कुछ करूं। लेकिन ये वो जो जिस जगह पे मैं टीचर थी, उस जगह पे नक्सल का काफी प्रभाव था, तो उससे मेरा क्या गुनाह था, मैं तो बहुत, लेकिन उस दौरान कई नक्सल ने कुछ आश्रमों को इसलिए तोड़ा था क्योंकि यहाँ पर पुलिस आके कई महिलाओं से छेड़छाड़, भाइयों के साथ मारपीट, करंट शॉट ऐसा दिया गया, इसलिए कुछ आश्रम को तोड़ दिया गया, लेकिन मेरे आश्रम को इसलिए मुझे लगा, मतलब मैंने अपने आश्रम को बचा, माँ वाली से खुद मेरी लड़ाई हुई कि आपने, मेरा ये कहना था कि अगर इनका स्कूल आशाना तोड़ोगे तो बच्चे कहाँ जाएंगे, आपकी लड़ाई किससे है? आप कहते हो कि ये हमारी लड़ाई इन जनता के लिए, यहाँ इनके हक के लिए, कि जब जनता के लिए, तो आप स्कूल तोड़ेंगे तो इनकी तो शिक्षा खत्म हो जाएगी। ये हमने लड़ा और स्कूल को बनाए रखा, लेकिन सरकार किसी ना किसी तरह हम पे ये आरोप लगाती, ये तो नक्सलवाद से मिलती है, ये नक्सलवाद को सप्लाई करती है, ये नक्सलवाद का समर्थन करती है, ये करके हमको जेल डाल दिया। लेकिन हमारे जेल जाने के बाद जो कि 200 बच्चे थे, तो 200 बच्चे मेरे जेल जाने के तुरंत स्कूल में जाके पूरी पुलिस ने मार पीट सब, वो बच्चे सब, और आज वो 200 बच्चे का स्कूल मात्र 12-13 क्लास में चल रहा है। तो ये स्थिति है, तो मेरा क्या होता? उसके बाद हमको जेल में लाया गया, जेल इस तरह जेल आने से पहले इतना दिया गया, और ये मतलब कहना चाहिए हम जैसे लोगों को ये मतलब भुगतना पड़ता है जेल में। और वैसे जो संतोष के साथ वही पत्रकार था, वो पत्रकार तो आदिवासी के लिए लिखता था, जल के लिए लिखता था, और लोगों के अपनी कोई घर की लड़ाई उसने नहीं किया। उनका ये कहना था कि ये जो हो रहा है गलत हो रहा है, इन आदिवासी साथ ऐसे नहीं होना, उसको जेल में डाल दिया गया, उसको लगभग 2.5-3 साल रख के उसके साथ इतना मारपीट किया गया। तो मेरे पति भी कोई ऐसे माओवादी नहीं थे, मेरे पति तो सीधी जगह में रहते थे, गिरम में रहते थे, उसको घर से उठा के ले गए, नहीं तुम भी जो नक्सल का सप्लाई नक्सलाइट के लिए सामान दे, तो उनको 3 साल रखा, उनके साथ वो उनको इतना मारपीट किया गया क्योंकि बार-बार ये कहा कि तुम अपनी औरत को दबाओ, तुम अपनी औरत को बोलो लड़ाई करना बंद कर, सरकार के खिलाफ बोलना बंद कर, ये बोलकर को जो मारपीट किया गया, उनकी सर में चोट आई जिससे पैरालिसिस हुआ, उसके बाद वो मौत की घाट उतार दिया गया। तो ये सब चीजें हर मतलब वहाँ हवा दिखा। अभी मैं आ रही थी और मुझे आने से पहले बस्तर में ये बात बोले, एक टीचर है, वो टीचर का एक मतलब मीटिंग हुआ, उसने कलेक्टर ने बोला कि अब स्कूल खुल चुका है, आप सारे टीचर गांव में जाके बच्चों को बुला के लाइए और अपना स्कूल में दाखिला कीजिए क्योंकि अब स्कूल शुरुआत हो चुका है। वो मौखिक से कहा, लेकिन उस टीचर ने जाके गांव में बच्चे ढूंढने गया था, उसको माओवादी करके कहाँ का ये पर्चा टिफिन बॉक्स सब जब्त करके दिखा दिया, टीचर को अंदर कर दिया। अब बताइए टीचर अंदर होगा तो वो कह रहा था, उसका जो परिवार मुझसे फोन करके कहता है कि मैडम कलेक्टर ने मीटिंग में बोला, मान लो कलेक्टर की बात ना मानी तो उस टीचर की नौकरी चले जाएगी, और उसकी बात का पालन करने के लिए जंगल की ओर जाते हैं, वहाँ तो हमारे आदिवासी रहते हैं ना उनके जंगलों में, उसमें जाएंगे तो उनको जेल में उनको डाल दिया जाता। तो ये स्थिति हमारे जेलों में बहुत है, और सिस्टम बदलने की बात कहेंगे तो सिस्टम बदलना भी वर्तमान में पुलिस जो रैली कर रही है, पुलिस जो धरना प्रदर्शन कर रही है, जो छत्तीसगढ़ में सब परेशान है, आदिवासी भी परेशान है और आज पुलिस भी परेशान है, वो धरना प्रदर्शन कर रही है, कांधा करके जेल झुरी का दारा लगती है। तो आज पुलिस वाले बोलते हैं मैडम जब आपके लिए हमने रैली किया, आपके खिलाफ आपको केमिकल अटैक करवाया गया, उस समय हमारे सर हमको भी पता है कि केमिकल अटैक किसने करवाया, और आपके खिलाफ धरना प्रदर्शन इतना पुतले दान के, तब तो ये लोग शाबाशी दिया। जब आज हमारे घर की महिलाएं अपने हक के लिए निकली तो हमको नोटिस करवा रहे, मतलब छत्तीसगढ़ की ये स्थिति की आज पुलिस भी वहाँ धरना दे रही है, वो भी अगर जेल के अंदर हुए उन पे भी देशद्रोही की तरह धारा लग रही है। तो ये हमारा पूरा सिस्टम और पूरा छत्तीसगढ़ का सरकार का तो यही हाल है। तो जब तक सिस्टम में बैठे जो राजनेता नहीं बदलेंगे तो तब तक तो यही होता है, शायद हम सिस्टम कभी ना बदल पाए। तो मैं खुद भी एक आप पार्टी से जुड़ी हूँ, तो मैं खुद इस बात को अच्छी तरह समझती हूँ कि कुछ कई मुद्दे में उठाती थी, लोग बोलते थे राजनीति कर रहे राजनीति, इसलिए अब इस बार हमने छोड़ दिया। हमने बोला अब इस बार चुनाव भी नहीं लड़ेंगे, लेकिन अपने समाज और अपनी बस्तर अपने छत्तीसगढ़ की लड़ेंगे हम, ताकि चुनाव भी ना लड़े, राजनीति से थोड़ा हट करेंगे तो शायद हम कुछ अच्छा कर सकते हैं।
कॉन्फ्लिक्ट जोन में जो पॉलिटिकल प्रिजनर्स हैं उनकी स्थिति बहुत खराब है। जो सरकार के साथ जो संघर्षरत जनता है, आइडियोलॉजिकली जो जनता लड़ रही है सरकार से, उसके साथ सरकार का जो व्यवहार है वो असंवैधानिक है। सरकार संवैधानिक तौर तरीके से, कानूनी तौर तरीके से पॉलिटिकल प्रिजनर्स को डील नहीं कर रही। ये कॉन्फ्लिक्ट जोन की सबसे बड़ी समस्या है। जो कॉन्फ्लिक्ट जोन में जो पॉलिटिकल आंदोलन चल रहे हैं जल जंगल जमीन के, सरकार छत्तीसगढ़ के कॉन्टेस्ट में उनको माओवादी करके संबोधित कर रही है और उनसे निपटने के लिए जो एक छत्तीसगढ़ विशेष जन सुरक्षा कानून बना हुआ है उसमें हम देख रहे हैं कि न्यायालय के स्तर पर भी भेदभाव हो रहा है। अगर जन सुरक्षा कानून लगा है तो आपको जमानत नहीं मिलेगी। अभी हाल में ही एक साल का मामला सुकमा में JNFC कोर्ट में चल रहा है। उसमें तेलंगाना स्टेट के हाई कोर्ट के 2 वकील, 2 सामाजिक कार्यकर्ता, उस्मानिया यूनिवर्सिटी में शोध करता एक स्टूडेंट, ये सब लोग छत्तीसगढ़ के बॉर्डर पे भद्राचलम में फैक्ट फाइंडिंग करने आए थे और वहां के लोकल जो पुलिस एडमिनिस्ट्रेशन था उसको उनसे कुछ प्रॉब्लम थी। उनकी फ्रेंडशिप छत्तीसगढ़ में बस्तर जोन के आईजी से थी। SRP कंदूली वहां के आईजी थे। वहां की पुलिस के रिक्वेस्ट पे वो लोग रात को 8 लोग रात को हैदराबाद से बस में टिकट बुक करा करके वो लोग आए और आंध्र प्रदेश स्टेट ट्रांसपोर्ट की बस से आए थे। उस बस का टिकट था, उस टिकट में उनका नाम, जो सीट रिजर्वेशन था उस पे उनका नाम था। वहां से उनको पुलिस ने उठा लिया और संयोग की बात ये थी कि जो दोनों हाईकोर्ट के एडवोकेट थे वो 3 बजे के आसपास आंध्र प्रदेश हाईकोर्ट में वो अपीयर हुए थे और ऑर्डर भी पास हुआ के आर्गुमेंट से। उनको यहां ले आकर के उन्होंने एक फर्जी केस तैयार किया। पुलिस ने अपना जो छत्तीसगढ़ का जो कॉन्फ्लिक्ट इलाका है वहां पे पुलिस 2 प्रकार के रोजनामचे चला रही है। एक रोजनामचा तो जो न्यायालयीन कार्य में जो एक्चुअल रोजनामचा है वो चलता है, लेकिन वो उसको चलाते नहीं है, उसको रोक के रखते हैं। जो घटनाएं होती हैं उसके लिए फैक्ट रोजनामचा बना के रखे हैं और हर डेट पे 1-2-1-2-1-2-1-2 हर डेट पे वो टाइम रोजनामचा, अगर जो वकील है सब जानते हैं कि थाने का एक ऐसा रिकॉर्ड है जो घंटे घंटे चलता है, उसमें हर घंटे का विवरण डालता है। जो थाने का ड्यूटी ऑफिसर होता है रोजनामचे में वो हर घंटे उसको बढ़ाता है। थाने के लोग किसी भी काम से थाने से बाहर जाते हैं तो रोजनामचे में डाल के जाते हैं और जब काम करके लौटते हैं तो रोजनामचे में उसको डालते हैं। वो जो भी गतिविधि थाने में होती है वो रोजनामचे में दर्ज होती है और न्यायालय उस पर बहुत विश्वास करती है। रोजनामचे पुलिस का वो एक प्रकार से ब्रह्मास्त्र है उसमें लिखी हुई बात सच मानी जाती है। उसमें रोजनामचा 1 महीने पहले से बैक डेट से उन्होंने पुलिस ने मेंटेन किया कि उनके पास 15 तारीख को एक मुखबिर ने आकर के बताया कि नामजद बताया कि ये बी रविंद्रनाथ, ये रविंद्रनाथ पाला, 5-7 लोग जो सारे लोग थे, उनका सारे लोगों का नाम उस मुखबिर ने बताया कि ये लोग वहां पे वो इलाके में कोई नक्सल लीडर है, उनसे मिलने के लिए लोग आते हैं, गांव वालों से मिलते हैं, ताना सरकार बनाते हैं, बनाने के लिए कहते हैं, जनता को सरकार के खिलाफ लामबंद होने के लिए कहते हैं। इस तरह का वो पूरे 1 महीने में 4-4, 5-5 दिन के गैप पे वो रोजनामचा डालते हैं। जब वो लोग अरेस्ट हो गए, उनकी जमानत की बात आई, तो जेएमएफसी की कोर्ट में बेल के समय उन लोगों ने अपना टिकट पेश किया कि पिछली रात हम लोग बस में बैठे थे और इस टिकट में हमारा नाम है, देख लीजिए जज साहब। और ये हम लोग हाईकोर्ट में अपीयर हुए थे, उसका ये ऑर्डर शीट है। उसके बाद उनकी बेल खारिज हो। कोर्ट ने कहा कि नहीं, इनके ऊपर विशेष जन सुरक्षा कानून बना हुआ है। उनकी बेल डिस्ट्रिक्ट कोर्ट से खारिज हो गई, उनकी बेल संयोग से हाई कोर्ट से भी खारिज हो गई। हाई कोर्ट के जज साहब ने भी पता नहीं कैसे ध्यान नहीं दिया कि जिस तारीख को उनको बताया जा रहा है कि वो बस्तर में नक्सली नेता से मिलने के लिए घूम रहे थे, उस दिन वो उसमें एक उस्मानिया यूनिवर्सिटी का लड़का था जो परीक्षा दिया था उस दिन, जिस दिन उसको रात को निकला था, उसके दिन में वो परीक्षा दिया था, उसके परीक्षा हॉल का अटेंडेंस रजिस्टर में उसका नाम। सेकेंड डे किशोर जी ने मूव किया था और इन्होंने फिर से हाई कोर्ट को कहा कि आप वो देखिए, उसमें वो जिस तारीख को बताया जा रहा है उस तारीख को वो कोर्ट में अपीयर हुए थे। तो जज साहब ने उसको कंसीडर किया, और वो इसलिए कंसीडर नहीं किया कि वो हाई कोर्ट में अपीयर हुए थे, इसलिए उन्होंने कंसीडर किया था कि चार्ज के स्टेज पे एक सेक्शन जो है वो कम हो गया। जो बस्तर की जेल है वो पॉलिटिकल प्रिजनर से भरी हुई है, और सिर्फ एक कार्यक्रम चल रहा है छत्तीसगढ़ शासन का कि जो पॉलिटिकल प्रिजनर्स हैं उनके प्रकरण को चलने नहीं देना। 7 साल 8 साल से वो सारे प्रकरण न्यायालयों में बंद पड़े हुए। जो पॉलिटिकल प्रिजनर्स हैं उनकी कोर्ट में केस ही नहीं हो रही। 3 कंडीशन हो रही। पहला, उनको कोर्ट में जिस दिन केस नहीं करते हैं, जिस डेट को सुनवाई होनी रहती उस दिन उनको केस नहीं करते हैं। जिस दिन पेश करते हैं उस दिन गवाह नहीं आता है। जिस दिन वो कोर्ट नहीं जाते हैं उस दिन गवाह आ जाता है। कभी दोनों पहुंच जाते हैं, मुलजिम भी पहुंच जाता है, गवाह भी पहुंच जाता है, उस दिन जज साहब नहीं रहते। ये छत्तीसगढ़ में पॉलिटिकल प्रिजनर्स के लिए बड़ा प्रॉब्लम हो गया है कि शासन को ज्योतिष विभाग से मदद लेना पड़ेगा। आप ज्योतिष से तय कीजिए कि किस दिन वो शुभ घड़ी होगी जब जज भी रहेगा, मुलजिम भी रहेगा और गवाह भी रहेगा, और तब जाकर के प्रक्रिया शुरू होगी। जो जब सोनी जेल में थी तो उनके प्रकरण में मुझे 1-2 बार जाने का मौका मिला। इनकी समस्या थी कि रायपुर से इनको सुकमा ले जाते थे, रास्ते में कहीं इनको पानी नहीं पिलाते थे। मैं जब इनसे मिला पहली बार सुकमा में, इनसे पहले उसके मिला नहीं था, तो इन्होंने इसकी शिकायत की कि मेरे को ये लोग पानी नहीं पिलाते। तो पॉलिटिकल प्रिजनर्स को तोड़ने का जो इन्होंने अपने सेशन में बताया, जो पॉलिटिकल प्रिजनर्स हैं उनको सरगुजा जिले के जो पॉलिटिकल प्रिजनर्स हैं उनको उन्होंने जगदलपुर की जेल में शिफ्ट कर दिया और जो जगदलपुर के पॉलिटिकल प्रिजनर्स हैं उनको सरगुजा की जेल में शिफ्ट कर दिया। सरगुजा से जगदलपुर की जो दूरी है वो 700 किलोमीटर है और जेल सुपरिटेंडेंट अलग बात कहता है और जो उस केस को देखने के लिए जो पीएचयू से जो अधिकारी तय किए गए हैं जो इनको लाने ले जाने की स्थिति को देखेंगे, पुलिस लाइन में उनको आरआई ब्रीफ करता है कि इनको रास्ते में थोड़ा चाय पानी ठीक से मत देखना। थोड़ा बहुत पुलिस वाले जो हैं वो सस्पेंड और टर्मिनेट होने की दांव में मानवीय आधार पर उनको चाय पानी का थोड़ा बहुत इंतजाम वो लोग कर देते हैं। तो छत्तीसगढ़ में जो पॉलिटिकल प्रिजनर्स हैं उसी समय जब लिंगा भी जेल में थे, लिंगा से भी मिलने में जेल में गया था, तो जो जेल सुपरिटेंडेंट थे वो मेरे मित्र थे। तो मैंने उनसे कहा कि मैं थोड़ा लिंगा से मैंने अलग से बात करना चाहता हूँ। बोले कि पंडित जी सरकार की तरफ से अलाउ नहीं है, आप जाइए वहां बैठिएगा और मैं किसी काम से उसको बुला लूंगा, अगर उतने में आप बात कर लीजिएगा तो कर लीजिए। तो उन्होंने बुलाया और मैंने लीगा से पूछा तो लीगा कहा कि भैया ये बोली मारते सुबह दोपहर शाम माँ की गाली देते हैं। तब तक वो अधिकारी फिर से आ गया और जो गाली उसने बताया था मैंने लीगा के सामने उसी गाली को पूछा कि तुमको ये गाली कौन देता है। तो जो आप अगर कॉन्फ्लिक्ट जो छत्तीसगढ़ के कॉन्टेस्ट में मैं बात कर रहा हूँ, अगर आप छत्तीसगढ़ के बस्तर की जगदलपुर सेंट्रल जेल का विजिट करेंगे तो जिन लोगों के ऊपर विशेष जन सुरक्षा कानून लगाया गया है उनमें खून की कमी है। और वो उनकी स्थिति मरने जैसी है। उनका और उनके प्रकरणों में जो गति है वो गति नहीं है। उनको जो वकील कानूनी सहायता दे रहे हैं उनके बस में नहीं है कि वो जल्दी से उनके प्रकरणों का निराकरण करा सकें। यही छत्तीसगढ़ में और ये पता नहीं क्या परिस्थिति है कि अगर किसी के खिलाफ विशेष जन सुरक्षा कानून की धारा लगी हुई है उस केस में क्या गंभीरता है इसको ये विचार नहीं हो रहा है, न्यायालय के स्तर पे विचार नहीं हो रहा है। और बहुत साधारण और फर्जी मतलब बहुत सारे प्रकरणों की कहानी ये है कि बहुत सारे प्रकरणों में कॉमन कहानी है कि रात को हमला हुआ था, लोग फायरिंग के दौरान एक दूसरे का नाम ले रहे थे और उस नाम को जो लोग ले रहे थे उसमें 10-15 लोगों का नाम लिया गया था और रिपोर्टकर्ता ने उस रात को 12-13 लोगों का नाम रख लिया था और उसने नाम लिखा दिया और उन जिन लोगों का नाम लिखाया गया है उनके गांव का पता नहीं बताया गया है, उनके बाप का नाम नहीं बताया गया है। बस्तर में जो लोग नहीं है उनको नहीं पता है। बस्तर में नाम को समझना बड़ा मुश्किल है। मरकम हिड़मे मरकम, लक्ष्मी हिड़मे, वो बहुत मुश्किल है। आप समझ नहीं सकते कि ये एक्चुअली किसके खिलाफ बात की जा रही है। बहुत कॉमन नाम है जो उनके लिखने का अपना तौर तरीका है। ये पूरी परिस्थिति है छत्तीसगढ़ में जो कॉन्फ्लिक्ट एरिया में जो पॉलिटिकल प्रिजनर्स हैं।
I have been a lawyer for last 9 to 10 years and also associated with the Human Rights Law Network for that same period. The topic here is the condition of political prisoners in conflict zones. So when we talk about conflict zones, there is some common features which prevail in these areas. like this conflict zones, in our case, it may be Chhattisgarh, Maharashtra, Odisha, Jharkhand. So all these states are very rich in mineral, and all these states there is a Maoist movement going on, and most of these states have a very large tribal population. So in these areas, the situation of political prisoners means prisoners who have been implicated for their own ideological thinking, which is not in line with the state or the government. So because of their own belief or ideology, they have been falsely implicated or they have been implicated in a case but treated in a different way. So these political prisoners are kept in context of Chhattisgarh, basically in the regions of Bastar, and I have some data of this region which I want to share now. The entire Chhattisgarh, the capacity of the jails are 9,267, and it actually houses 19,473 prisoners, which is it is more than double. And now coming to the conflict areas, there are three main prisons: Jindal prison, Kanker and Sonepat. So Jindal prison has a capacity of 889 and it has 1954 prisoners. Kanker 165 is the capacity and it has 400 inmates. And then Sonepat 150 is the capacity and it has 652 prisoners. So sometimes 3 times, 4 times the number of prisoners vis-a-vis its actual capacity are kept. So if you can see the kind of overcrowding in this area, which are mostly affected by the Maoist area. Now I would like to discuss a pattern of cases. It's a real case. Suppose a blast takes place in Chhattisgarh. So what will be the modus operandi of the police? They or the security forces. They immediately go to the area. They will conduct search operations and randomly they will pick up villagers without having any previous clue about their involvement in the blast. For all these persons will be kept in illegal custody without having prepared the arrest memo. And for 5 days, 6 days, they will torture. Suppose 10 persons are picked up, 5 will be released after this 5 days torture. 5 out of 5, 2 might have been killed in fake encounter also. 3 persons will be produced in the before the magistrate. So when they are produced before the magistrate, the magistrate has a duty to ask that whether this person was tortured or not. So it never happens in a magistrate court. I have not seen a single magistrate who has asked that this is specific question when the police produces him that whether this person was tortured or not. In all the cases, invariably all the prisoners were tortured before producing. And when it comes to grant of bail, be it in the High Court, be it in the Sessions Court or 4th and 7th Magistrate Court, the government council they presently say that my lord, this person will be eventually be acquitted. So only time we can keep them in jail is during the trial. So please don't grant bail. After hearing this argument, the judge does not scold. He forgets that the main object of the bail is not to punish, but to ensure it attendance in the trial. So, despite all this kind of arguments being advanced by the government, council bail is refused. And when after going through a long trial, the person is acquitted. When the person is acquitted, he comes out of the jail. And there are many cases. The moment the person comes out of the jail, he is informed there is another case against you. So again, he is taken back into custody. So there are cases in Jindal court which I have personally known, where girls have been put in jail in the age of 15-16 years, and they were released when they become 30. And after release, the kind of mental trauma or physical trauma they have undergone, they have a different kind of mindset. They cannot mix up with the mainstream society. And I want to especially stress on the political prisoners who are journalists, the journalists who basically have some left in living, and they have reported police excesses in coastal areas. All these journalists, I think 4 or 5 in number, have been booked by the state government, and subsequently after a very long time, some of them were released on bail. One of the journalists is named Santosh Yadav. When the jail authorities came to know that he has filed jail application in the Supreme Court, the superintendent of the Jindal, the civil district, and the jail authorities, and there are some other persons who are called Lambardar. Lambardar are the prisoners who are undergoing life sentence. All of them assaulted him with lathi and with some sort of rubber can, and they kept on assaulting him till he lost his conscience. So, and after that, without the consent of the family members, he was taken to some other jail in Kaki. And because he was under strike on that time, so this was done in that case. And now also he is outside. Sometimes he talks like a person not normal, who is not normal. So this kind of behavior is being meted out to the political prisoners, journalists, lawyers. The lawyers have to. There are some lawyers who are practicing the Jindal area. They have to leave the place, and comments are passed on the lawyers who practice in the High Court. Some sort of national lawyer, all these tags are being used to mentally harass these lawyers. So this is the kind of situation under which the lawyers have to work, and also the journalists, the defenders, the person who are actually taking up cases of Adivasis have to face. And not only this, that some person is having this political ideology they are harassed. Even in case of police persons, there is a police constable who was terminated, and he tried to educate other constables only with respect to the hike in their payment, improvement of their service condition, weekly off. All this, he got an order from High Court, and now he has been booked under sedition. So this is a case where 3 police persons have been booked under sedition. When they die, they are martyrs, and when they question something which is not good, they become anti-national in that case. So this is a whole scenario, particularly in the state of Chhattisgarh. And I want to end by quoting Justice Deepak Gupta when he was Chief Justice in our case. I was arguing a case with respect to sexual assault to 40 or 50 women in Bastar area, and there were several allegations put forth by the government council that this is anti-national, all these things. So very bravely he said that it is not anti-national to accuse security forces of rape. So that statement is still in my mind, and it gives me a lot of courage. So with that I have to end.
And many of you all who are here also know him, that he was one of the key persons who took up the cases of political prisoners right from the start of his career. Colin Gonsalves and other people also know that ever since a young lawyer, he has been taking up TADA cases, and after TADA relapsed, OTA, NA, UAP, and Nagpur. And because of that, mainly because of that, he had become an honest state. And just last month, that is actually just this month, on 6 June, he was arrested by the Pune police. The same police who, while Surendra Darling was defending Professor Sai Baba, threatened him in the sessions court that your number is next. The same police, the same officers came to his house, searched his house, and arrested him. And now he's in the same case of UAPA, the Unlawful Activities Prevention Act. If the divestment would be there, it would be part of this discussion here out here. So the context of political prisoners, I thought it would be best to start off with that note. Actually, what our three speakers spoke about, that this is something in law which actually doesn't have a place in law. In that sense, you will never find a definition of political prisoners, the treatment of political prisoners, you will find nothing in our law books. You can find it in CRPC, IPC, whatever you want to find it. So, where do we come out with this understanding? I would, for that little background, I would want to go into the background how I would see what makes up a political prisoner, the history of it, about it, and last and least, I'm going to the problems, the difficulties that the other people have resolved. Soni ji ने पहले बताया दामन के बारे में, फिर बाकी सुपा का केसेस के बारे में जो बताया और बाकी जो केसेस के बारे में जो बात करेगा, लास्ट में जो बात करेगा कि उनका जो ग्रीवियंसेस है, उनका समस्या क्या है, मैं आखिर में बात करेगा. Actually, ever since, right from British times, there has been a differential treatment with regards to political prisoners. Now, if anybody has read the old books which were written from Andaman Nicobar jails or people who had got to the jails and come back, you would see there was definitely a very clear classification of political prisoners. So you would either get S stitched on their clothes to make a sedition का charge, और राज कैदी के नाम से उनको दिया जाता है. मतलब उनको एक स्पेशल कैटेगरी, एक स्पेशल. The point I'm trying to make is that from the British days, ever since what we call modern law, from that time onwards, there has been a differential treatment by the detaining state vis-a-vis political prisoners. It started off with अलग-अलग names, जैसा मैं पेश किया, seditionist को नाम बोलते थे, conspiracy case prisoners, राज कैदी, state prisoner, detaining. फिर मतलब 1947 के बाद भी अलग-अलग नाम से भी यूज करता था. Even in the West Bengal government, even had a special act with regards to political prisoners. All these are there. So the state, on its part, has enforced a differential treatment for political prisoners. But on the other hand, जैसा बाकी लोगों ने भी बोला था, जब जेल में जो व्यक्ति जो उनको मालूम है कि वो उनको पॉलिटिकल प्रिजनर है और उनका अलग से ट्रीटमेंट भी किया जाता है, जब वो व्यक्ति बोलेगा कि हाँ आप बोलो कि मैं पॉलिटिकल प्रिजनर है, at that time the state will deny it, because in essence a political prisoner, like the first guy, is an essence to recognize a political prisoner would mean to say your democracy is false. So in that sense, I would want to come out to this point is that although the state will give differential treatment to political prisoners, it will treat them differently with regards to torture, under trial, or conviction. Like Dr. Murli was raising the question about lifers. You know, in Maharashtra, there is this extremely weird rule. We are talking about 14 years, 20 years, but in Maharashtra, all those who have been convicted from the 93 bomb blast case, mainly Muslims, so-called terrorist case, Tara case, they have given a likhan, what's called likhan, probably in Marathi is called likhan, but that is the final how many years you will be spending here. They have been told they will be spending 60 years in jail. Now, this is a category made by a state. The remission category in Maharashtra, there are various categories. For women, they will be released after 20 years. For if it's a personal crime, it's a domestic crime after 22 years, 24 years, 26 years, and for terrorist crimes, not less than 30 years. So, the point I'm trying to say is that the government, the detaining authority, has already recognized a different category. But if you go to claim it, no, it won't be recognized. I'll go to the next slide, where actually this type of different category was recognized from the British times. It was a name called Reginald Braddock. Actually, he conceptualized the idea of political prisoners. उसका कहना क्या था कि जेल में जो कैदी लोग हैं, जो आम कैदी लोग हैं और जो राजनीतिक कैदी में एक विभाजन रखना चाहिए. क्यों? क्योंकि उनका कहना है कि ये राजनीतिक कैदी बाकी आम कैदी के साथ में रखेगा तो उनका विचार, एक्चुअली उसने शब्द जो यूज किया उसने यूज किया कि उनका गन, उनका विचार बाकी लोगों पे फैला जाएगा. इसलिए क्या starting say from British days there has been a policy of separation of political prisoners. So if you remember, the first separations would be by transportation. बर्मा में उनको लेके जाना, उनको वहां तक भेजना. फिर उसके बाद काला पानी आ गया. फिर काला पानी में सबको भेजना मुश्किल गिर गया. तो in Jharkhand, what's called Jharkhand now, there is a Hazaribagh jail that became the first political prisoner jail. It was identified as a high security jail where उस समय का जो आजादी करने वाले जो कैदी थे, जो लोग अंडर ट्रायल्स थे, उनको वो जेल में दिया जाए. This practice still continues. This practice continues even now. साई बाबा जो है, उनको एक हाई सिक्योरिटी यार्ड में रखा गया नागपुर सेंट्रल जेल में. That high security yard जिसको बोला जाता है अंडा बैरिक. Now Sai Baba, everybody knows he is a professor, ex-professor of DU. He has been suspended, removed from his job. He is a 90% paraplegic. He has a disability, and he is kept in a high security yard. Why? Because his thoughts should not be spread with the rest. अंडा बैरिक जो है, मैं खुद देख चुका है वो अंडा बैरिक. अंडा बैरिक में जाने के लिए आपको 7 गेट पार करना पड़ेगा. मतलब मेन जेल को छोड़ो, मेन जेल में अंदर आने के लिए आपको अलग, लेकिन अंडा बैरिक के बाहर से एंट्री जाने के लिए आपको 7 ताला खोलना पड़ेगा. That is the way secularization and isolation is kept, which I'll talk a bit later on. But the point I'm trying to make here is that this kind of differential treatment, the government through all its rules, I can give lots of examples. The points that Amarnath ji said is typical. Not only is happening in Chhattisgarh, it's happening in Maharashtra, it's happening in various cases that ये जेल नक्सलाइट कैदी या कश्मीरी कैदी या आतंकवादी ये सब लोग के लिए हानिकारक है, इसलिए क्या करना, उनको हाई सिक्योरिटी जेल में दिया जाए. तो जिस जेल में उनका घर के लोग नजदीक है, वो जेल से निकाल के उनको 200-300 किलोमीटर का दूरी का जेल में रखा गया. What happened in Maharashtra is that there was a jail started in Gadchiroli. उनको यूज नहीं किया क्योंकि ये नक्सलाइट प्रिजनर्स हैं, उनको वहाँ पे यूज नहीं, वहाँ पे रख नहीं सकते. उनको शिफ्ट किया उनका गांव से कम 300 किलोमीटर दूर चंद्रपुर जेल में. चंद्रपुर जेल में कुछ दिन के बाद उनको लगा कि नहीं, मुश्किल है, यहाँ पे भी सिक्योरिटी का प्रॉब्लम है. वही 120 आदिवासी बॉयज जो है, उनको शिफ्ट किया नागपुर, जो उनका घर से या गांव से 800 किलोमीटर दूरी पे है. कुछ लोगों को उसमें से उनको शिफ्ट किया अमरावती, जो और भी दूर पे गया. मतलब कम से कम गांव से जाने के 1000 किलोमीटर से. जो जिस प्रकार से उनको आइसोलेट करो, जो अलग प्रकार से ट्रीटमेंट करो, और जैसा अमरनाथ जी ने बताया था वही है कि हाई सिक्योरिटी के नाम से, मतलब उनको पॉलिटिकल प्रिजनर्स की कैटेगरी नहीं बोल रहे, लेकिन हाई सिक्योरिटी के नाम से उनके कोर्ट में पेशी नहीं किया जा रहा है. महाराष्ट्र में हमको अंत में एक पीआर, मतलब हमारी जो संगठन है, जो सिविल लिबर्टी संगठन है, हमको नागपुर जो सुरेंद्र रेड्डी ने ही फाइल किया था, नागपुर हाई कोर्ट में बेंच में हमको एक पीआर दाखिल करना पड़ा कि आपका गडचिरोली जेल चालू है, उसमें गडचिरोली जेल को चालू करो और ये बिजनेस को डालो. मतलब we did not ask for release of prisoners, but we asked the jail and let the prisoners be in jail because उनका घर से नजदीक है. This is the प्रॉब्लम कि स्टेट किस प्रकार से पॉलिटिकल प्रिजनर्स को एक अलग से ट्रीटमेंट कर रहा है, लेकिन रिकग्निशन का जब बात करेगा, जब हम लोग बोलेगा कि नहीं हमको पॉलिटिकल प्रिजनर्स का स्टेटस दे दो, वो इनकार करेगा. आई गिव यू गुड एग्जांपल, दैट इज इन वेस्ट बंगाल. वेस्ट बंगाल द गवर्नमेंट हैज, आई डोंट रिमेंबर द एग्जैक्ट, प्रॉब्ली जो वेस्ट बंगाल रीजन लोग हैं, या फिर इट्स कॉल्ड वेस्ट बंगाल करेक्शनल सर्विसेज एक्ट, ऐसा कुछ है, जहाँ पे कैटेगरी है पॉलिटिकल प्रिजनर्स का. So in that category, there was a section saying that all those arrested under Chapter 6 of IPC, that is offenses against the state, should be entitled for political prisoner status. What happened is that some people, political prisoners in West Bengal, had written to the government asking for political prisoner status. ना तो कुछ और मिलने वाला नहीं, कुछ किताब मिलने वाला है या खाना और एक्स्ट्रा मिलने वाला है, वैसा कुछ नहीं था. But they asked for political prisoner status. The court and the government interpreted it कि नहीं, it is only those involved in non-violent crimes. अभी जो भी लॉ समझते हैं, IPC में Chapter 6 is dealing with war against the state. means it essence it means violent crimes. लेकिन गवर्नमेंट ने उसमें पकड़ गया, अंत में हाई कोर्ट में गया, हाई कोर्ट में द जज रूल्ड इन फेवर ऑफ द प्रिजनर्स बट he hinted to the government कि ये कायदा में सुधार लाना चाहिए, the कायदा should be amended, and the government very well made an amendment to it, and the amendment stands कि political prisoners का category है, लेकिन unlawful activities prevention act में जो भी arrested है उनको ये category से नहीं किया, यानी it's like a way out, they are recognizing political prisoners, but टाटा unlawful activities prevention act में ऐसा तो नहीं, मतलब torture का सेशन में भी मैं सुन रहा था और एक बातचीत हो रहा था कि the torture bill has been drafted and all that. Another situation, the torture bill which was drafted by the government, it talks about making complaints against torture, but it has a provision saying all those arrested under unlawful activities prevention act or special laws cannot complain. So you yourself, that the government itself is creating a category, but when we ask for recognition, is denying it. I'll go further. What historically what happened is that if all of you must be knowing that Bhagat Singh had and his friends had strikes against political prisoner status. Now what is because बहुत लोग बोलते हैं कि भगत सिंह ने ये स्ट्राइक क्यों किया क्योंकि यूरोपियंस को एक स्टेटस मिल रहा था, उनका इच्छा था कि हमें भी वो स्टेटस देना चाहिए, वैसा नहीं था. It had a very strong anti-imperialist, anti-racist सेंटिमेंट है कि अगर उनको तुम अलग कैटेगरी में दे रहे यूरोपियंस को तो हम भारत को क्यों नहीं दे रहे. सो वन मेनी ऑफ द स्ट्राइक्स हैपेंड देयर एंड दे आस्क्ड फॉर पॉलिटिकल प्रिजनर स्टेटस एट दैट टाइम. साथ साथ में एक चीज है, मैं क्यों ये चीज पेश करना चाहता कि इट इज अ फ्लिप साइड ऑफ ये पॉलिटिकल प्रिजनर स्टेटस में. जब ब्रिटिश का काल में जब पॉलिटिकल प्रिजनर्स का स्टेटस था तो एट दैट टाइम देयर वाज अ प्रोविजन दैट some of them would be given other food and also some people who went into got arrested as Congress leaders and all that, they started getting special ghee and special food and all, and there was a chance of buying them off. Go ahead. I just go briefly into these things now. These are the definitions that the state tries to put forward, means seditious, conspiracy case prisoners. Now at the moment the state is trying, अगर आप जेल में जाएगा तो मानिए अभी कितना जेल में क्या है, लेकिन जेल में आप जो गेट में जो कैदियों का लिस्ट आता है उसमें कैटेगरीज है, उसमें आएगा कैटेगरीज की कॉन्विक्स इतना, अंडर ट्रायल्स इतना, टाटा कैटेगरीज इतना, यूएपीए के लोग इतना, यानी स्टेट इज आल्सो आइडेंटिफाइंग पीपल अकॉर्डिंग टू पॉलिटिकल प्रिजनर्स. I just want to get 2 or 3 definitions जो जनरल पॉलिटिकल प्रिजनर्स किस लोग को बोला जाता है. There has been 2 definitions put forward by Amnesty International. They are based on definitions on violence and non-violence. Means Amnesty International has this concept of prisoners of conscience. That means that basically it's if that prisoner is supposedly not advocating violence. And they have another concept of political prisoners is that he may not advocate violence. So that they have these 2 concepts. This is one definition which is there, just going through it. Then there are definitions where it's a pro-oppressed type of definition, जहाँ पे बोलते हैं कि अगर वो जनता के साथ में लड़ाई करता है और वो कारण से उनको टारगेट किया जाता है, या उनका विचार भी जनता के प्रति क्या हमदर्दी है वो कारण से सरकार को टारगेट किया जाता है, या उनका रेस और सरकार का एक पूर्वाग्रह के कारण, बिकॉज ऑफ द प्रेजुडिस ऑफ द स्टेट, ये बीन टारगेटेड. फॉर एग्जांपल बॉम्बे में अक्सर मुस्लिम लोगों को क्योंकि आतंकवादी है उनको जेल में तो डाला जाता है, लेकिन अक्सर मुस्लिमों को वेस्ट बंगाल मुस्लिम्स को बांग्लादेशी के नाम से उनको दिया जाता है जेल में डाला. तो दिस टाइप ऑफ टारगेटिंग, दिस टाइप ऑफ पॉलिटिकल बिकॉज ऑफ द बायसनेस ऑफ द स्टेट. This is a category which I just briefly want to talk about, is that the prisoners of war status. There are some organizations internationally and nationally who talk about giving political prisoner status according to prisoners of war concept. जहाँ पे conflict zones में this is a big, very important question कि कश्मीर में या छत्तीसगढ़ में जहाँ पे इस प्रकार का कैदी को लाना चाहिए, जैसा मैं पहले पेश किया था, गवर्नमेंट will not be willing to accept there is a war. either in Kashmir or in Chhattisgarh, Maharashtra, Jharkhand. So the question of accepting the recognition of political is a problem. But this is a concept put forward by various organizations. Lastly, मैं जो बात करना चाहता हूँ कि ultimately जब हम लोग political business का बात कर रहे हैं, one of the biggest demands is for the unconditional release. कि हम लोग मानते हैं कि उनका जो incarceration itself, जैसा सुरेंद्र करने का बात किया या अन्य लोग का बात किया, जैसा सोनी जी ने बात किया कि उनका incarceration itself is a political bias. इसलिए when you have to fight against for that unconditional release. लेकिन उसके अलावा there are 3 or 4 points which I thought of mentioning कि actually ये नया points नहीं है, लेकिन political prisoners के लिए ज़्यादा ही important है. जैसा बता के रखते हैं torture और cruel treatment में, क्योंकि ये political prisoners in conflict zones की बात करने का recently हमारा कुछ lawyers ग्रुप्स में कश्मीर में गया था एक फैक्ट फाइंडिंग करने के लिए. वहाँ पे lawyers का क्या problems है और वहाँ पे बहुत लोगों ने बोला कि जनता का विश्वास ही उड़ गया जुडिशरी के ऊपर. तो अक्सर वहां का जनता जब किसी का एनकाउंटर होता है तो व्हाट डू दे डू, दे ब्रिंग द बॉडी टू फ्रंट ऑफ द जुडिशरी. वहां पे घोषणाबाजी करेगा और घोषणाबाजी के बाद स्टोन पेंटिंग विल बी डन ऑन द कोर्ट्स. तो इस तरह का सिचुएशन में द प्रॉब्लम इज द because this situation the government is forced is going into a position where the basic human rights of a political prisoner, be it torture, malicious media trials, जैसा मैं शायद सुरेंद्र करनी जी के बारे में आप लोग सब लोग जानते हैं, उसी के ऊपर राइट टू डिफेंस, कभी-कभी उनको भरोसे वकील नहीं दिया जाता है, फ्री एंड फेयर ट्रायल और प्रोड्यूस ड्यूरिंग प्रोसीडिंग्स, इनको जैसा बाकी लोग ने बात किया, ये पॉलिटिकल प्रिजनर्स के लिए ज्यादा भी इम्पोर्टेंट है. और जो पॉइंट में जो बात किया जो पॉलिटिकल प्रिजनर्स के लिए खासकर इम्पोर्टेंट है कि जेल में उनको आइसोलेट किया जाता है, उनको क्वारंटाइन किया जाता है. दिस इज समथिंग वी हैव टू स्पेसिफाई. आई जस्ट गिव वन लास्ट एग्जांपल कि एक बॉम्ब ब्लास्ट एक्यूज जो है, जो स्टेट उसको होता है अबू जिंदल, उसको उस सेल में रखा गया जहाँ पे कसब को रखा गया, मतलब एक आइसोलेटेड सेल. The cell having 3 or 4 layers with lead lining and cement and अलग-अलग जो चीज़ है जो ना तो सूरज जा सकता है ना तो किसी को मिल सकता है. The problem is कि जब कसब के लिए बनाया गया था हम लोगों ने हाउस में उठाया क्योंकि हमको लगा कि कसब तो ही डिजर्व है, लेकिन वो सेल को अभी उस अबू जिंदल के लिए यूज कर रहे हैं. वो सेल अबू जिंदल के बाद किसी और पे यूज करेंगे, कल परसों हमारे लिए भी यूज करेंगे. The point of that is that we have to start raising our voice at these extraordinary situations, क्योंकि कल परसों यही चीज ordinary बन रहा है. Extraordinary laws are becoming ordinary. Thank you.
Gopal Gandhi. Allegation against him was that he was a member of the Politburo of a Maoist organization, and that he was a mastermind behind many bomb blasts. The first case was filed in Delhi, and then they filed 17 cases against him, identical charges. Politburo member of Maoist Party and the main conspirator as a result of his several bomb blasts took place. He's been in jail, I think, now 8 or 9 years. And in those 17 cases, there are about 10 acquittals, 3 discharges, etc., etc. So now 3 cases remain against him. The acquittal orders are very interesting when you read them. And every acquittal order says there is not an iota of evidence against him. Either that he was a member of the Politburo or that he was part of any conspiracy to do bomb blasts. Can you imagine? Now 8-9 years in jail, going from court to court, and every court is acquitting him or discharging him, that there is not an iota of evidence. And the moment one case ends, the other case begins. So now the case began in Jharkhand, then the case is beginning in West Bengal and so on. So he spent his life in jail and he's likely to die in jail because his health condition is very bad. Classic. Now in all these cases, if you look at the child, a member of the Politburo of a Maoist organization, The most important judgment that you must read is the judgment of Justice Kaju. You know the text, and that judgment was a very nice judgment of Kaju. Kaju said you may be a member of any organization, but if you have not committed any overt act, then there is no crime. So let's say I'm a member, sympathizer, friend, whatever of a Maoist organization. If I don't do any overt act, it is no crime. So now even if you accept the charge sheet at face value that you were a member of a Maoist organization, right? There was no overt act alleged against him. Alleged. Forget proof, not even alleged against him. It's very classic. Now I know Gopal Gandhi. When I was younger in college and so on, Gopal Gandhi was the ideologue of the Marxists. Ideologue in the sense that he would be training and teaching students in the overthrow of capitalism and the transition to socialism. I think I used to meet him, I knew his wife, Anna. They were never people who engaged in the use of force, but their weapon was their minds and their tongues. So they would speak of the overthrow of capitalism and the bringing into India of socialism. A classic political case, where because you are political, you are classified as a criminal. And Gopal faced the legal challenge. He said, even if you accept my charge sheet, even if you take the charges at face value, what crime have I committed? And they could not answer the judges in 13 matters. And he will die in jail. He is now 70 plus. He will die in jail. And no judge is willing to give him bail because these are very serious terrorist charges. They are not willing to look into the precedents of all these acquittals of the identical charges. Not willing to look into it. So this thing about stigma, that you can use a magic mantra, terrorist, this, that, Maoist, it's a magic mantra, and the judiciary will close. You stop functioning, you will stop thinking. Judges will stop thinking, judges will stop functioning, judges will forget about conditions for bail, everything, because you have used a magic mantra. And it is used extensively in the country. There are people who engage in terrorism, full force of the law against them. There are people who engage in violent activities and wage war against the state. Use the violence, the law justifies using the full force of the law against them. But not against people whose minds and tongues are their only weapons, not bombs and knives and guns. And that is a very big lacuna in our judiciary today. And people are afraid to provide legal aid to so-called terrorists. I looked at Gopal Gandhi's papers, he said, will you appear? I looked at his paper, I said, I'll appear for you gladly. Anywhere, anytime, and speak on your behalf. Because I saw all the acquittal orders of the courts. Too late, no? Acquittal order will come after 5, 6, 7 years. He's in because of that magic word terrorism. Therefore, there's young people. Don't be misled by terms. Maoist, this, that. Don't be misled by terms. Always look at the hard facts of the case. Always look at the hard facts of the case. Because the police have misused these categories for too long. And it is time for lawyers to fearlessly stand up. Go by the facts of the case. Maybe the person has used violence and you understand what the case is all about. Go by the facts of the case and don't be afraid to defend. Soni Sori was also called a Maoist. I defended her. She would always say, what are you doing? I think her father was attacked and his bulldozer or something was burned. Your father was attacked. There was some difference about the answers. And she said, I was the only person in Chandigarh who raised the flag. She's fighting against the state. She's fighting against the army. She's fighting, but she's currently as a teacher raising the flag. She said, who stands for that raising the flag? We defended her comfortably, no problem at all. They made 8 cases against her, all 8 false cases. 7 acquitted, 1 case is lingering on now. You get acquitted there, all cases. But nobody was willing to defend. And particularly in conflict zones, young lawyers must show courage to go and defend cases like this. And there are many cases like this. Many cases. You must show courage. Courage of your conviction, not to be deterred by what people try to threaten. This is threat actually. That will put you in also, if you go and do these kind of cases. So we'll take 5 minutes of 5-7 minutes of questions. If any, need not be questions also, it could be comments. But the political session raises very important issues relating to free speech. Free speech is not just, okay, free speech is really tested when you come to issues like that. Maoism. That is when free speech is tested. When you speak against fascism, which is a growing phenomenon in our country. When you speak there, then the right to free speech is severely curtailed, then you understand what the meaning of free speech is.
And because I can speak for NASA, not otherwise, when we talk of jail lok adalats, I think should we spend 2 minutes on what lok adalats are? Everybody is aware of lok adalat? It's an ADR mechanism. Let me still repeat for my sake. And it's an ADR, alternative dispute resolution, and it's applicable to civil as well as criminal. We should be aware of that also. Primarily, ADR is civil. Section 89 CPC provides for alternative dispute resolution and ACGM, as we call it, arbitration, conciliation, judicial settlement, and mediation. But Section 19 of Legal Services Authorities Act 1987, it for the first time introduced this term Lok Adalat in a formal way. And Lok Adalat is of late we also came to know some people are misusing the term Lok Adalat because Section 19 provides for what Lok Adalat is and who can hold a Lok Adalat. We found that certain departments, some ministries, they have started holding their own Lok Adalats. Any Jindal Adalat and all that. Lok Adalat is a body which is two-member body. We have to always keep this thing in mind. There has to be a judicial member who can be a sitting or a retired judge. There can be no alternative to this. A sitting or a retired judge. And the second, what Section 19 provides is other person. This other person can be a panel lawyer. We have such process in DLSA panel lawyer, SALSA panel lawyer. This can be a doctor. This can be an engineer according to the need of the subject. Like when we hold Lok Adalats for motor accident claim cases, we prefer to have an orthopedician so that we understand what kind of surgeries are required, what is the expenses which will be required, and what are the post-operative processes which have to be looked into. So this is two-member body which we have to understand. Section 21 also provides for and let us not make any confusion between this fact that any award passed by Lok Adalat is only with mutual consent. Lok Adalats do not pass judgments as a matter of law, and there is the settlement is on mutual terms. The terms are recorded, both the parties read it, sign it, the judge Lok Adalat and the member Lok Adalat then sign it, and then it becomes a Lok Adalat award. This award carries the force of a decree, as we understand, which is executable under Order 21 of Code of Civil Procedure. So you don't have to go file a suit. And Lok Adalat, the unique thing about it is that it can be held for a pre-litigative stage also. Pre-litigative means there may be a case where no suit is pending or no case is pending in any court of law. So before anything goes to the court, we hold pre-litigation Lok Adalats. Like I can give you examples. MTNL, this telephone, bills, certain credit card bills, some small petty loans. They are also looked into. These are the areas which we cover. And when we are discussing this, one more thing I will like to spend 1 minute is there is another entity of this sort we call it as permanent Lok Adalat. Have you heard of this? PLA as we call that. PLA may sound like a Lok Adalat, but it is a totally different thing. Because PLA under 21A of Legal Services Act has a dual advantage. It is a better option than a Lok Adalat. One, PLA is only for pre-litigation things. Two, if in the PLA, the settlement is not arrived at as per mutual consent, अगर दोनों पार्टी राजी नहीं हो रही हैं, तो the Lok Adalat has also the power to adjudicate, and that adjudication is again binding. So there are sections of the society or the banks and they are not happy with this. They say that when you say adjudication, then adjudication there is no evidence which you are taking. It's a very formal environment there. But PLAs are working very successfully. Haryana में public utility services ज़्यादातर PLA में covered है. Delhi में only electricity is covered. I don't know much position, but our data shows that there are hardly 100 plus PLAs in India. We should have it like as I shared 651 districts we have, so we don't have even one PLA in every district of the India. Now coming to the Lok Adalat in jail. Now Lok Adalat in jail, as we understand, when you say in jail, meaning thereby the case is already registered, it's not a pre-litigation, it's a pending case. But when a man is inside jail, Lok Adalat can be done only on criminal compounded cases. You know, section 320 CRPC, we have a list, and this has a two bifurcation with permission of the court and without permission of the court. If a compounding can be done in the court, why you have to go to the jail? So we, NALSA as a policy, we do not have any guidelines or something like that to hold a Lok Adalat inside the jail. Because when we are talking of prisoners' rights, we have to talk of complainants and victim rights also. Making a victim travel to the jail and as we discussed in the earlier session, going to the jail is not a pleasurable exercise. You reach to a place, then you are get to wait at the gate, and then फिर आपकी checking होगी, and then you do those entries. तो एक victim को आप इतना परेशान करो और अंदर ले जाके फिर वही काम हो जाए तो हावी हो जाता है. So as a policy, we are not doing Lok Adalats in jails. Another topic is jail adalats, and I think I'll request her to say about Lok Adalats in jails if you have some experience to share. As far as jail adalats, so jail adalats is a totally different thing. That is, उसमें lok word नहीं आया. So we are not talking of Legal Services Act. We are talking of a judge, criminal judge, making a sitting in the jail. That is treated as a criminal court. Instead of courthouse, they are holding a court on a particular day inside the jail house. So that is happening, not a problem, because in Delhi we had separate sittings for very grave offences. You are all aware, lately this gentleman Ram Rahim, the court was held in Sunaria jail in Rohtak, in the state of Haryana. He had the sitting there. There are some other instances in Delhi where a high-profile prisoner, the security issues were such. We have system in Tihar jail where you can go and hold courts. We have system of holding courts in Vigyan Bhavan NXC also. So notification comes and you hold court. But when we talk of jail adalats, you are talking of a judge going to the court. Announcement is made to the people. In cases who are petty in nature, suppose some couple of bottles of liquor or a knife or some other offences, so उसको हम लोग बोलते हैं कि you come there, plead guilty, and then you are let off for the whatever sentence, 1 month, 2 months, 3 months, 4 months, you have underwent, and then उसको already undergone कर देते हैं या हिंदी में call it gratification. So it may not be, I don't know why it is added here, but it is according to us a very good way of getting a quick exit out of the trial thing, because trial will take a lot of time. Because yesterday in NHRC we were discussing magistrate court, you all know there has to be a hearing every 15 days. Is it so for sessions court also? No. There is no binding. But for a magistrate you have to give a hearing every 15 days. And these petty cases are primarily before the magisterial court. What they do is they have a system called Rehnumai, which I as a magistrate in my 10 years of magistracy since 97 I never believed in, because this is defined in Parliament's intent. कि आप लोग judges what they are doing is वो 3 महीने की डेट देते हैं, despite being a magistrate, और बाकी hearing effective होगी 3 महीने बाद, उसमें 6 रहनुमाई जोड़ देते हैं. So this is the wrong practices they are doing, And if somebody is not getting, even if they will not be passed, they don't have ways and means to furnish bonds, so they prefer to do okay, I'll plead guilty and I'll move on. So in Delhi, I can share on record, every third Saturday we have a jail adalat. We don't have local adalats. Every third day we have jail adalats, and in that case, 20 to 30 people are released every month in Delhi. Cases which are taken up are which are punishable up to 3 years. Repeat offenders are discouraged. We don't, every time you get caught taking somebody's pocket or maybe doing some carrying a knife or something, we don't allow that. If you are involved in multiple cases, one is attempt to murder or one is petty offense, then again we discourage that. So this is what is happening as far as jail local adalats and jail adalats.
I'm working with Prayas, that is Bombay Prayas. Attached to KSS. I'm basically working. I'm also a member of DLSA Mumbai and also the High Court Committee, various committees. And I was working for last 25 years with Prayas. And the High Court had given me hobbies premises in the Bombay Session Court because of our work. And with the direction to all session judges to refer cases of vulnerable people who are eligible for probation, PR bond, and bail. And the cases comes under PI. So this is my introduction. I'll just share my experience because while working in prison and taking up cases from jail and then providing them legal aid. I came across the judge who's coming there, magistrate, every week. Earlier it was like once in a 15 days or twice in a month. And those magistrates come there and ask who want to treat, and then those who are undertrial, they raise to raise their hands. Then he asks the court number, details, case number, and a date is fixed. And on that date, the particular magistrate in whose court his case was pending, he comes there and asks him to plead guilty, and then you sentence to him, whatever is under court. They call it set off. So that was the procedure before 2009. When I was not feeling comfortable with this procedure, then we have a lot of discussion with the member secretary over there and also the High Court judges. And then we have a interaction program also with the magistrate, which Prayas organized with the help of DLSA. And so many points come out how we can make this jail code, we call it jail code or jail adalat. How we can use this jail code concept for taking the prisoners, not only for pleading guilty, but other things also, like the undertaker can be released on PR bond. If he pay the visit to his home and we found that at least his parents are there, he has a house or he has some documents, or he has a relative or employer who is willing to take his responsibility, then accordingly, Prayas is to give report, social investigation report to the court, and then the court, after considering that report, is to release the person on PR bond. So my point was because they are not taking to their courts regularly, that's why they are pleading guilty. Because it happened in Bombay City, especially in certain locality like Kurla and all these places, where the undertakers are not taking for courts for 5 to 6 months or sometime 8 months for their regular court dates. So and they are just languishing there, and then they are forced to plead guilty. So if you are going to remove that forceful element, the person should plead guilty by his own wish. He should not be forced because he's inside, because he could not avail bail, because he could not furnish bail. That's why he's pleading guilty. That was not proper. So accordingly, we had a very much interaction with the magistrate and with the High Court also. And then, as sir said, they allow up to 3 years punishment. But there are so many cases which magistrate can try where the punishment is like 326, where the punishment is life. So slowly we change that into cases tried by the magistrate, and those cases can be taken in the jail court. Slowly then at jail court we start regularly. Now earlier it was like before 2009, like once in a week or 15 days in a week. Now there are regular everyday magistrates are coming there, and along with their cases files. And then they come there with the case file. Then so many things also we changes there. we also ask the Sarkari Vakil, APP, to come there also. So if anybody wants to release on bail, so his seat can be taken. Then the statement at the 311, that can be also recorded there. The charge can also frame in the local. So these are the things we try to implement there. So making that jail code not only to plead guilty, but actually a relief to the prisoners who doesn't want to plead guilty. And that really work, and we really help so many people. Now, again, the whole magistrate were there, now they change, they transfer. And again, the same procedure started, which was earlier. So it need to work, and there should be a changes into the law, so that thing can be worked out properly. There are so many prisoners we came across. Where one case I can tell you, the man was actually from Chennai, and he had he was a habitual. He was in so many cases pending here. He finished those cases and he got to Chennai. After 10 years he came back, and again he was caught on suspicion, and they put some false charge on him, his earlier case. And then his case was there. So after talking to me, he said, "Sir, I will go to Chennai. I don't want to come in Bombay." Then that case, he pleaded guilty and he was given 100 sentence after consulting with the magistrate. I used to sit with the magistrate in the jail court, and then we discuss. It is nothing in on paper or in law, but that's how we try to reduce the population of the jail court. At the same time, we try to give justice to the people. There are so many cases I found where the person have not committed any offense, but still he couldn't avail bail because there was nobody outside to bail him out, or there is nobody to give surety. In such cases, we insist that the trial should be conducted, and then we provide them legal aid also. So this is my experience which I like to share, because it is now started in so many metropolitan cities. These are the new things, because state is failed to provide escort to each and every prisoner. Escort is a big issue. I don't know about Delhi, what is happening here. But escort in Bombay is a big issue. People are now taking for their dates for like 6 months to 8 months. In some cases, 1 year. So this is a big issue. And in order to escape from that issue, jail code is not the alternative. But we try to make jail code effective and which can help the prisoners to really get justice. That is my experience.
Having done, sir, we at NARSA came to know that in Rajasthan, in Madhya Pradesh, in Maharashtra, there is a problem of people not being produced before a judicial court. It's a constitutional right that within 24 hours we have to be produced before a magistrate. And CRPC provides that every 15 days we have to be produced before a magistrate. So in the name of lack of armed personnel or personal assets, all the conveyance and other problems, logistic problems, the accused are not being produced. I think it's a basic violation of a human right. You can't be remand a person for another 15 or another 15 and then you say 6 months. I think it's very, very gross. In Delhi, we cannot even imagine a single remand happening. Even if there is for any reason a holiday or something, some judicial officer goes to in jail and then personally do it. One change has happened that we have now started doing some remand via video conferencing. It is highly debatable. Some people say it's a good thing. Lot of nations' money is saved. Then some people say it's not that good because somebody is being tortured. And when you see a face on a video conferencing, you see only the face. You don't see what are the other muscle men standing around that person. He can't make a complaint. But when accused used to come to us for a remand purpose, he can talk to us. Sir, I have this problem. Please, मेरा ये इलाज नहीं हो रहा है. मुझे ये problem है. मेरे को ये दवाई लेनी है. Even मुझे चश्मा लगाना है. मेरा चश्मा टूट गया. Nothing of this sort is happening. So automation and mechanization and modernization and IT, they have both the flip sides. So now what is happening in jail? I'm told in Haryana they have done some good thing, and legal services have been empowered. Another thing.
Thank you, sir. जो दो टॉपिक है बोलने के, एक लोक अदालत और एक जेल अदालत। जेल में लोक अदालत हो नहीं सकती, वो सब नहीं बता दिया, क्योंकि लोक अदालत के लिए जरूरी है दोनों पार्टीज का होना, विक्टिम का भी और अक्यूज का भी जेल में विक्टिम तो होता नहीं, तो एक तरफा तो लोक अदालत नहीं हो सकती। तो जो जेल वाली जो अदालत है उसको अगर लोक अदालत कहा जाए तो वो सिर्फ मिसनोमर है। जेल में सिर्फ जेल की जैसी अदालत कोर्ट वहां लगती है कोर्ट में, ऐसा ही कोर्ट जेल में लगाया जा सकती है और ऐसे ही हरियाणा में लगा रहे हैं। सिर्फ अंतर इतना किया कि पहले जो सेक्रेटरी डीएलएस थे वो जाके कर लेते थे, फिर सर ने थोड़ा सा उसमें जब सर हादसा में थे खान साहब उन्होंने थोड़ा इम्प्रूव अपॉन किया। और एक तो ये हुआ कि हरियाणा में जितनी भी सेक्रेटरी हैं डिस्ट्रिक्ट लीगल सर्विसेज अथॉरिटीज के, they all have been conferred with special power of special judicial magistrate first class, so that they can go to the jail and go to the अदालत। सेकेंड is कि अभी वो भी अकेले नहीं जाते, उनके साथ एक मजिस्ट्रेट की और ड्यूटी होती है, तो 2 ऑफिसर्स हमेशा जाते हैं। ये हरियाणा में प्रैक्टिस आई डोंट नो व्हाट अबाउट द रिमेनिंग स्टेट्स। तो 2 ऑफिसर जाते हैं और एक पैनल एडवोकेट जाता है। वो एडवोकेट का मुझे लगता है कि मंशा ये रही होगी कि अक्यूज को कोई तो रिप्रेजेंट करने वाला होना चाहिए। तो जो पैनल एडवोकेट की जिसकी हम ड्यूटी लगाते हैं वो जाके अक्यूज की तरफ से रिप्रेजेंटेटिव होता है, वो अक्यूज को रिप्रेजेंट करता है, और जो 2 जुडिशियल ऑफिसर होंगे वो जाके मैटर को सुनते हैं और डिस्पोज ऑफ करते हैं। इट इज लाइक ए नॉर्मल रूटीन अदालत जो जेल में लगाई जाती है। जहाँ तक दूसरी जो है लोक अदालत वाली जो बात है सर में, तो मुझे ऐसा महसूस होता है कि लोक अदालत जो शब्द था ये सिर्फ भारत देश में हो सकता है और इसको सिर्फ हिंदी में ही समझा जा सकता है, इंग्लिश में इसको समझा ही नहीं जा सकता। आप कितनी जान लगा लो, क्योंकि ये शब्द ही हिंदी की उत्पत्ति है लोक अदालत, जन अदालत। जो पहले जन अदालत हुआ करती थी, आम जनमानस की अदालत हुआ करती थी, उनको हमने छोड़ दिया और वेस्टर्न कंट्रीज ने उनको साइंटिफिक बना दिया। जितने भी ये एडीआर मैकेनिज्म है ये सभी की सभी भारत देश की देन है, लेकिन हमने कहीं ना कहीं धीरे धीरे करके जो ब्रिटिशर्स ने हमारा जो जस्टिस डिग्री सिस्टम जो डिजाइन किया उस पर आ गए और अपना जो इनहेरेंट सिस्टम था उसको हमने छोड़ दिया और उस सिस्टम पे यूरोप में या वेस्टर्न कंट्रीज ने बहुत रिसर्च किया, रिफाइन किया, साइंटिफिक बनाया और अब हम उसे साइंटिफिक जब वो बन गया हम उसे वेस्टर्न से दोबारा से हम उसे इंपोर्ट कर रहे हैं। तो दिस ऑल एडीआर मैकेनिज्म जो है ये सारे के सारे एडीआर मैकेनिज्म, चाहे वो मीडिएशन है, चाहे वो कंसीलिएशन है, चाहे वो लोक अदालत है, ये सब हमारे ही देन है। लोक अदालत में ये है कि जैसे 2-3 तरह की जो भी लोक अदालत है, अब हरियाणा में तो कई तरह की और भी बढ़ा दी है। हमारी एक डेली लोक अदालत होती है कि कोर्ट जैसे 4 बजे तक कोर्ट की सिटिंग है, 4:30 बजे वही कोर्ट 4:30 बजे या पहले 3:30 था 4:30 है कि जो भी टाइम है, टाइम के आधे घंटे बाद वही जुडिशियल ऑफिसर उसके साथ में एक पैनल एडवोकेट की और ड्यूटी लगा दी जाए तो वही लोक अदालत में कन्वर्ट हो जाते हैं। सभी कोर्ट्स मोर और लेस सभी कोर्ट्स को लोक अदालत में कन्वर्ट कर दिया जाता है रजिस्ट्रार की तरफ से। तो ये डेली लोक अदालत होगी। फिर नेशनल लोक अदालत करते हैं, क्वार्टरली लोक अदालत करते हैं। लेकिन एक ये भी मिसकंसेप्शन था कि लोक अदालत सिर्फ सिविल केसेस में होती है। जैसे सर ने बताया था कि पेटी केसेस जो है, क्रिमिनल कंपाउंडेबल केसेस जो है, जो सेक्शन 320 में बताए हैं, ये पेटी केसेस में 260 में मेंशन है, 266 में है, उनके लिए भी लोक अदालत में उनका निपटारा किया जा सकता है या और किसी जो स्पेशल स्टेट्यूट्स बने हुए हैं उनका भी लोक अदालत में निपटारा किया जा सकता है। लेकिन मैं जो बात कहना चाह रहा हूँ, these are all जो बेसिकली स्टैट्यूटरी बातें हैं और स्टैट्यूटरी बातें सभी स्टैट्यूट में हैं। तो आप सब बुद्धिजीवी हैं या तो स्टूडेंट्स हैं या लॉयर्स हैं। लॉयर्स को पढ़ाया नहीं जा सकता, ना कोई ट्रेनिंग दे सकता है, लॉयर्स से समझदार कोई नहीं है, दे आर सोशल इंजीनियर्स। मैं ये कहना चाह रहा हूँ, माय क्वेश्चन इज कि खुद की खातिर खुद से मैं जीवन भर लड़ता रहा, खुद की खातिर खुद से मैं जीवन भर लड़ता रहा, तूने ऐसा पाठ पढ़ाया मैं खुद को ही भूल गया। मोर और लेस जब भी किसी सिविल सूट पे या क्रिमिनल लिटिगेशन में भी जब दो पार्टियों के बीच में एक एंडलेस लिटिगेशन चलती है तो the genesis of the dispute lies in the ego of the parties, more or less. At times it is in different aspects also, but majority of the cases are resting on the ego. And how this ego problem can be solved if the ADR mechanism, जो ADR mechanism है हमारे, यदि लोक अदालत है चाहे लिटिगेशन है, यदि उनको स्ट्रेंथन किया जाए और वो हिट करे जिस पार्टी की ईगो की वजह से चीजें मल्टीफोल्ड बढ़ती जा रही है, लिटिगेशन एंडलेस होती जा रही है, तो दिस प्रॉब्लम कैन बी टैकल। बट फॉर द सेम वी नीड टू बी एक्सपर्ट एंड concentrate and concentrated on the particular issue कि where lies the core issue, किसी ईगो प्रॉब्लम की वजह से है कि ये एंडलेस लिटिगेशन बढ़ते जा रहे हैं। सो जहाँ तक लोक अदालत का प्रश्न है, लोक अदालत में मुझे ऐसा महसूस होता है, देयर में भी अदर व्यू आल्सो, कि लोक अदालत में सिर्फ उन केसेस का ही फैसला हो सकता है, होना चाहिए और होता है जहाँ पे जो उनकी ग्रेविटी कम है और ईगो के इश्यू ज्यादा है। सिविल साइड में क्रिमिनल में कंपाउंडेबल दैट इज सेकंड, बट इन सिविल साइड में जहाँ पे ईगो इश्यू ज्यादा है और जो चीजें एट स्टेक है वो बहुत थोड़ी है, तो उनके जेनेसिस जो है वो ईगो में है। जहाँ पे स्टेक पे बहुत थोड़ी चीजें हैं, वहाँ पे ईगो को यदि हैंडल कर लिया जाए पार्टीज की तो उसका सॉल्यूशन हो सकता है। और हरियाणा में जो प्रैक्टिस है कि पीएलए पीयूएस जो है परमानेंट लोक अदालत पब्लिक यूटिलिटी सर्विसेज, पब्लिक यूटिलिटी सर्विसेज की मैं गुरुग्राम का जैसे एग्जांपल यदि कोट करना चाहूँ तो तकरीबन 500 एप्लीकेशंस गुरुग्राम में पेंडिंग है पब्लिक यूटिलिटी सर्विसेज में, तकरीबन 500। ये चाहे वो बिजली का बिल है, चाहे वो आपको एजुकेशन से रिलेटेड जो स्कूल या फीस या उनसे रिलेटेड स्कूल पीएलए में ले आए हैं, टेलीफोन का एक्सचेंज का है, और इस तरह की बहुत सारी चीजें जो सेक्शन 21 में है, 20 चैप्टर 6A में है लीगल सर्विस अथॉरिटीज एक्ट के 22 to 25 में, उसमें लिस्ट है प्रॉपर कितनी सारी चीजें हमारी जो है पब्लिक यूटिलिटी सर्विसेज में काउंट होती हैं और उनको कैसे इनफॉर्मल वेज में। अगर मैं एक लाइन में ये कहूँ कि यदि लोक अदालत का सबसे बेहतरीन इस्तेमाल हो सकता है हरियाणा के दृष्टिकोण से, तो पब्लिक यूटिलिटी सर्विसेज की जो लोक अदालत है वो है, क्योंकि उसमें इतनी चीजों को इन्वॉल्व कर लिया गया है कि रोजमर्रा के जीवन की जितनी भी चीजें हैं, जितनी भी डिस्प्यूट्स हैं, जितनी भी परेशानियां हैं, बिजली की, पानी की, एजुकेशन की, वो सारी की सारी पब्लिक यूटिलिटी में आती है और वहां पर इनफॉर्मल मोड को अडॉप्ट करके जितनी जल्दी उनका सॉल्व हो सकता है, वो जो हमारा ट्रेडिशनल जस्टिस डिलीवरी सिस्टम है, जो कोर्ट बेस्ड लिटिगेशन जो है, एडजुडिकेशन बेस्ड जो है, वहां पे इतना नहीं हो पाता। तो एज एडवोकेट्स, एज द सोशल इंजीनियर्स और द बड़े जजेस, स्टूडेंट्स, अगर इस चीज को ज्यादा से ज्यादा हाईलाइट किया जाए, ज्यादा से ज्यादा आम जनमानस तक पहुंचाया जा सके, तो ये एक पाथ ब्रेकिंग हो सकता है, एक बहुत बड़ा चेंज सोसाइटी में ला सकता है और ये बहुत कम इसका प्रचार प्रसार हुआ है ऐसा मुझे लगता है। बाकी चीजें तो सर ने बताई दी है, यदि किसी का कोई पर्टिकुलर क्वेश्चन हरियाणा से संबंधित होगा
one thing I want to share with you, and that is जो permanent ये जो daily continuous लोक अदालत है, this we tried in Delhi in 2014 when I was working with the state authority। ये state आरसा की साइट पे भी DSNSA.org पे ये प्रोटोकॉल which I had the opportunity to design, it is available। और उसमें हमने नेगोशिएबल इंस्ट्रूमेंट एक्ट के सारे केसेस को मैंडेटरीली लोक अदालत में डेली कंटिन्यूअस लोक अदालत में भेजने का प्रोसेस स्टार्ट किया। ये एक्सपेरिमेंट हमने अभी 6 महीने पहले पटियाला हाउस में किया। ये वस्टर वर्ड ऑफ पटियाला हाउस कोर्ट्स न्यू दिल्ली डिस्ट्रिक्ट है, वहाँ पे 79,000 की पेंडेंसी है, उसमें से 49,000 चेक बाउंस केसेस So, Delhi, the district judiciary is inundated with negotiable instrument act cases. बहुत सारे लोग कस्टडी में भी हो जाते हैं, जब तक प्रवेशन हो जाती है, तो नीचे तो बेल हो जाती है, आपकी 289 है, कौन सा 389 CRPC, but the sessions, because I have done a lot of cases, sessions में आते थे, जब हम कन्विक्शन करते हैं तो हम बेल नहीं देते, फिर हम जेल ही भेज देते हैं. So, हर जेल में any given point of jail आपको 100 से ज़्यादा कन्विक्ट 138 check box में मिलता है. So, the Delhi continuous flow अदालत is very important. Because you are here, I want to share a development which is very closely related to India, may not be related to Lok Adalat. That is, have you heard of 3rd of May 2018 ordinance in Commercial Courts Act? Anybody? You have not heard of this? 3rd of May 2018, President Shri Ramnath Kovind has signed amendment, and the Commercial Court Act 2015 has been amended. And a new chapter has been introduced, chapter 3A, section 12A has been added. The definition of commercial dispute has been changed. As on date, before the amendment, only commercial dispute का आप अगर definition पढ़ेंगे 2C में, तो 75 to 80% of all civil suits आपने जितने आज तक सुने होंगे सब commercial dispute में जाते हैं. India was criticized world over ease of doing business में हम लोग 185 देशों में से 144 पे हैं. Enforcement of contract में हम 185 देशों में से 166 नंबर पे हैं. तो हमारे यहाँ पैसा लगा के आदमी अपनी किस्मत ही खराब, बाहर वालों को तो लगता है कि एक बार कोर्ट में केस आ गए तो वो डिस्प्यूट खत्म नहीं होते. तो उसके प्रेशर में अभी ये अमेंडमेंट्स डाले हैं. तो 1 करोड़ और उससे अभाव वाले डिस्प्यूट कमर्शियल डिस्प्यूट होते थे. 3rd of May से 3 लाख है उससे अभाव वाले सारे डिस्प्यूट कमर्शियल डिस्प्यूट होते हैं. और जो सबसे बहुत बेहतरीन अच्छी बात जो उन्होंने इस अमेंडमेंट में डाली है कि कमर्शियल डिस्प्यूट यानी 3 लाख और उससे अभाव का सूट आप अदालत में नहीं डाल सकते जब तक आप 3 महीने नालसा के अंदर उसको प्री सूट मीडिएशन ना करें. सो कांसेप्ट ऑफ प्री लिटिगेशन मीडिएशन एंड मैंडेटरी मीडिएशन मींस आपको अगर सिविल सूट डालना है तो आपको पहले नालसा की किसी बॉडी में डिस्ट्रिक्ट अथॉरिटी में या तालुक में आके हमारे को एप्लीकेशन देनी पड़ेगी. 3 महीने तक हम आपकी मीडिएशन वहां कराएंगे. सेटल हो जाएगा तो आपको जो अवार्ड मिलेगा वो सीधा एग्जीक्यूशन होगा. नहीं होगा तो ये पीरियड 2 महीने और एक्सटेंड हो सकता है. और फिर कभी हम आपको जब ये दे देंगे कि हमने कोशिश की सेटलमेंट नहीं हुआ तब आप कोर्ट में केस डाल सकते हैं. So it's a path-breaking thing which will change the way the civil litigation was looked upon in India. I am keeping my fingers crossed. मुझे ऐसा लगता है कि बार एसोसिएशंस will not take it lightly. लोगों को अभी ज़्यादा मालूम नहीं है. Because we were part and parcel of framing the rules. Last Saturday को Ministry of Home के law Department of Legislative Affairs के साथ सुनील जी और हमने जाके इसके rules finalize किए हैं और within this week the rules will be notified and the whole process will be through. And ऐसा मानना है कि सिविल डिस्प्यूट्स अगर जितने जल्दी रिजॉल्व होंगे तो उससे कहीं ना कहीं क्रिमिनल पे भी फर्क पड़ेगा. बिकॉज क्रिमिनल लिटिगेशन या क्रिमिनल डिस्प्यूट स्टार्ट होते हैं कहीं ना कहीं रूट किसी फ्रॉड को लेके होता है, किसी राइट ऑफ वे को लेके होता है, लैंड नॉट लीगल में डिस्प्यूट होता है. सो वही दैट इज सिविल डिस्प्यूट इज मोर और लेस जेनेसिस फॉर क्रिमिनल डिस्प्यूट्स. The civil dispute resolution is made easy and quick. This will also have bearing on criminal justice.
So we came all. We had a very interesting and brief session on the board visitors in the first. We talked about what, why, and how of prison oversight. We talked about international standards on prison oversight, the oversight mechanisms. We talked about primarily we talked about the United Nations Standard Minimum Rules. We talked about the United Nations Convention Against Torture and the Bangkok Rules, which all talk about the importance of inspections in prisons, about the oversight mechanisms. Then we talked about the kind of oversight mechanisms. We talked about internal and external mechanisms which are there. The internal would be the prison officers themselves conducting the business, and the external, which was the crux of the session, was about the board of visitors, which unfortunately is a body which I'm sure half of the people sitting here don't even know about. That's called the board of visitors. It comprises of official and non-official visitors. The official visitors are the judicial officers, there are the district magistrates, they can also be the superintendents, they are also what you say, members of the health or the public works department. So there are different members that come into the official visitors, and there are the NOVs. NOVs is somewhere when civil society and people, public sector individuals play a very important role, and this is where all of us can play a more important role in ensuring that whatever violations we've been talking about in the last 2 days don't happen. So this is, in totality, is called a mechanism called the Board of Visitors. We then talked about the criteria. We talked about how the functioning has not been up to mark, even though the Board of Visitors is a concept that has been in place since the Prison Act itself. However, the criteria for appointment of NOVs in particular has been very political in nature, where you often find MLAs are getting themselves onto these boards and they go inside and try and get special privileges to be made to their party men or to people that they may know. So we talked about these criticisms, then we talked about certain decisions of the Supreme Court and the Delhi court where HRLN has filed a case about appointments of visitors and how there was this incident where the Delhi prisons had actually made superintendents part of the non-official visitors body, the official visitors body, and how that is like a judge being a judge, it's like being a judge in your own cause, and how that had to be squashed because it wouldn't have become independent. So in a summation, we talked about the focus was that we all believe and they believe that surprise visits is very important to ensure that prison conditions are there and prisoners' rights are not violated. They should be independent, inspectors should be there, which are independent from any consideration whatsoever. No case should be there, no person I know should be there. I should not be part of any particular clan or a community inside it. So independence is very important. The non-political nature of the BOV should be there. Interaction with prisoners is something that must be there. You have to interact with prisoners to know what is right or wrong. Otherwise, what happens is you only see what the prison officials want you to see. And then we talk about free access. The access for going into any part of the prison, going and checking the solitary confinement area, going and checking what kind of food is being served. These were the key focus areas that we talked about in that session. Thank you.
I just add one or two more points. That in the non-official visitors, it's important that people who are independent are independent-minded are on the board. And we can look at the Sanjay Suri guidelines of Supreme Court 2011 case, which 1988 supplementary SCC 160, which says who can constitute visitors board, especially the non-official visitors. So those are the social workers, lawyers, social activists, media persons, retired public officials like retired judicial members, and it also there's some guidelines where they say that they have to be independent. They should not be part of the system. So that is very important to make sure that the visitors board is the body which can keep a check in the prison, so they have to be independent in that function. So we can ask
Yeah, our was parallel session 2 regarding changes needed in the Model Prison Manual. Model Prison Manual 2016. So our observation was that there is a chapter of prison offences, and one of the offences prescribed is refusing to eat food. This is the prison offences on which superintendent can give the punishment. So our recommendation is that this is a non-violent sort of protest and it should not be defined as a prison offence. Second was that there is arbitrary power given to the superintendent jail to forfeit the remission beyond 10 days without any appellate provision. So our recommendation is that there should be a proper mechanism so that this power is not misused. This should be checked. Another point was that in this manual, the prisoner have been asked to desist from singing, laughing loudly, and talking loudly, So our recommendation was that this is depriving the prisoner of basic rights. Another recommendation was that there is a provision in model prison network which say that superintendent can keep a prisoner in 30 days solitary confinement. Basically, solitary confinement earlier during the British era, it used to be in the one of the punishments, substantive punishment in the IPC. But after independence, the Honorable Supreme Court in number of judgments have had this unconstitutional. So when this has been held unconstitutional and it is not in the statute, how it could be in the model prison manual? Then about the women prisoner, there is provision that there should be one woman prison in each state. If you are having one woman prison in the east state for the exclusive argument of the women prisoner, it means if someone is in a state like UP, if woman is the resident of Ghaziabad, and that here has been constructed at Lucknow, means her relative will have to travel from Ghaziabad to Lucknow to visit the women prisoners. So
it's also mentioned that they should be launched as far as possible near their places.
Then no.
Responsibility mentioned that along with it from the rank of rules. I
No.
particularly remember
Yeah.
that they should
Yeah.
be launched closer to their places.
Basically, our suggestion here is that in the women part, the women could also be lodged in the man jail, but in the separate enclosure. So our recommendation is that they could be lodged in the separate enclosure of the men jail with the proper security arrangement. Then temporary release of women prisoner to deliver child in hospital. Our recommendation is that specific period should be given for the release of pregnant women, 1 month before delivery and 3 months after delivery. She could be released on temporary release. Then for child upkeep, there should be provision of pediatrician in the jail. Pediatrician may come from the civil hospital to that jail where women are kept. Then where both the parents are in the jail, it has been suggested that monetary help should be given where both the parents are in the jail and kids are outside. They are more than 6 years, they are outside. There is a law in Delhi, so on that pattern.
ये सुनिए इसमें मैंने आपसे सुबह सबमिट किया था ये जो स्कीम है I had the opportunity to draft this and my original draft which was filed in the revision bench of the High Court which was approved by the High Court was either the earning parent if the mother is housewife then husband is inside it is not necessary आप कितने cases conceptualize कर सकते हैं कि husband wife दोनों जेल में जाएंगे it will be 1 in 10,000 times. So if the earning father is inside the household lady or even the parents, then both should not be happening.
Sir, we are talking about 1 in 1,000 कह रहे हैं ना ऐसे भी अगर कोई है जिसपे हमारे
original scheme थी उसमें earning parent की बात
जी
vulnerability starts from the earning parent. both का मतलब कि आप देना ही नहीं चाहते both कहाँ होगा
जब मियां बीवी दोनों है और बच्चे बाहर हैं.
So, other than what you just pointed out, the basic idea of adding the provisions on women and children in the model prison manual was, I mean, the focus should be more on empowering them, enabling them,
and means and methods of rehabilitation instead of simply guarding them or detaining them. So along these lines, as so mentioned, improving the pre-existing infrastructure instead of simply adding additional ones. Then also specific, there's a need for detailed guidelines on the terms and meaning of physical search, especially as far as women Indians are concerned. There's no understanding of the terms of decency, privacy, etc. And moving on to that's pretty much it. Also, certain best practices that have been included in several states for foster care for provisions related to children. And also facilities for women prisoners who are foreign nationals, particularly their right to leave. In several cases, there's requirement of translators so as to facilitate better communication.